Okay, it's 10 o'clock, so let's resume. Just to recap where we've got to. We started off on Tuesday with a self-contained session on noise, and we heard both the council's case and the appellant's case on noise on that day. And then yesterday we heard, we moved to consider other matters other than noise, and we heard the case for the council, and we started hearing the case for the appellant. So we heard Justin Bass's evidence. So today we're going to continue hearing the case for the appellant, presented by Emma Dring. So.
Good morning, sir. Sorry, I'm just hastily trying to assemble my documents and things. Just bear with me 1 minute.
I apologise that my machine occasionally beeps. I've tried to look at the settings to make it stop doing that, but I haven't found out how to do it, so my apologies that happens from time to time.
Right. Okay, thank you. Sorry about that. Good morning, Mr.
Morning.
Ford. I'm going to introduce you by reference to the introduction section in your proof of evidence, and so obviously we've already seen Mr. Ford's got a proof and some appendices, which I don't know if you've got them in hard copy. I apologise for the lack of tabs and pagination. We seem to be able to work through it okay. Right, so you are Russell Ford, and you tell us that you have a Bachelor of Engineering degree in Electrical and Electronic Engineering. You then have a postgraduate diploma with distinction in Town Planning, and you were a recipient of the RTPI prize in relation to that. You're a member of the RTPI, and you have some 33 years of experience in town and country planning, both in the public and private sectors. You tell us that you had your first 10 years of development control experience in local government, and you were in fact employed by Castle Point Borough Council.
Yeah, I did my first inquiry here in 1992.
There we go. And you tell us a bit about your experience that you gained at Castle Point, and you were a full-time appeal officer and an expert witness for 3 years for Castle Point.
Yes.
And then you moved to Malden District Council in a more senior capacity, and you later left Malden to join Andrew Martin Associates in 2000, and you coordinated evidence for appeals. You were a lead consultant for a master plan for an urban extension. And then in March 2002, you formed Smart Planning Limited.
That's correct.
Independent planning consultancy. You're the principal director of that consultancy. Is that all correct and accurate?
It is, yes.
Thank you very much. Right. I just want to, before we kind of get into the main part of your evidence, pick up on a couple of points that the inspector raised yesterday through questions to Ms Hutchinson. And the first is about, obviously this is an outline application with access to be determined.
Yes.
And the question the inspector raised was about the plans and the status of the master plan, because we've got the access plan for Church Road,
Yes.
which has been submitted, and therefore what's then the status of the rest of the access matters. And the suggestion the inspector made was that he could determine potentially the access onto Church Road and then reserve the rest of the access matters for the detailed stage. Do you have a view on those points?
Yes, it was the junction of the Swan Neck Road, as we call it, with Church Road, that was really the subject of consultation with the local highway authority before we made an application, and it's that aspect that we seek to be approved in the appeal scheme. All the internal roads are really reserved. That includes the connection with Brunel Road, which of course is a private connection.
So the inspector can proceed on the basis that the only access matter that is to be determined at this point is that access plan showing the junction with Church Road, and that other matters are to be will be left for later.
That's correct.
determination.
Yes.
Thank you. And then the second point that was raised was this point about the Class E uses, the 3 Class E units that are shown on the illustrative master plan, and the proposal that those would take access through the estate, through the housing development. And the issue with Class E being quite broad and the potential nature of uses and whether there could be a conflict and those kind of points. Is there anything you want to say about that?
Yes, I mean, firstly, in terms of chronology, Class E wasn't around when we first started developing the master plan. It came part way through, and it was a strange beast. It is a strange beast, and we weren't sure how to handle it in the first instance. So we specified Class E. I think the difficulty with Class E over and above Class B1, and the reason we had Class B1 originally was because by definition it can take place, those uses can take place in a residential area without detriment by reason of noise, etc. And so it's a good complement, and it's also got a known car parking dynamic. Class E isn't the same as that. It involves a whole host of uses with a whole host of different external symptoms, some of which could conflict with parking requirements depending on who the tenants are. And their external symptoms might be quite different in terms of the days of use, times of day they operate, etc., etc. So it was never really part of the proposal to have a full expression of Class E. And I think the other key point is this. In the ERNA, the Employment and Retail Needs Assessment of 2012, there's a clear identification of a lack of office space, and that those... and Castle Point is a difficult place to provide offices because it doesn't have any significant centres. It has Hadley. It has Canvey Island Town Centre. Other than that, you sort of have smaller neighbourhoods. And so what the ERNA says is that you can look at Hadley, but you really ought to be providing your offices in mixed-use schemes. And ours is exactly that. It's a mixed-use scheme. So taking that all together, I really think that the correct solution for this master plan is that those buildings are, in old speak, would B1 offices, because there are potential problems beyond that. And I think it would be fair, if you accept that approach, that there was a restriction to that. In fact, notwithstanding that, I know the Secretary of State doesn't like restrictions.
And so just to be clear, are you suggesting effectively a condition limiting the use of those units to the equivalent of what would have been a B1 use, whatever the relevant subparagraph of Class
I think
is?
that's the right way to do it, because that way you dovetail with the ERNA, you have known traffic dynamics, you've got known good relationship with residential property, and it excludes all those unknowns that we never really wanted in the first place. Now, that doesn't prevent subsequent changes of use in the context of present-day development control in deserving cases. And I think the other point which the inspector raised was the potential for future changes of use. I think that, again, I'd be anxious, given the noise environment, which we fully recognise and have done from the outset, if those buildings which effectively form the noise barrier were to be provided with a more noise-sensitive use other than office, i.e. residential.
Thank you. I mean, obviously the inspector can raise this concern yesterday, or this is an issue. Is this something that the local authority have raised, this potential for any conflict with from the Class C uses, or has anyone else raised that you're aware?
No, not at all, no. I mean, those concerns I've expressed have rested with me throughout the project, and it was only through the inspector's question. And there's a suggestion in Alison Hutchinson's proof about difficulties with the external dynamics. And as I say, I share those, but it was never really part of the original master plan to have them.
All right. Thank you, and I'm sure you can be asked about that if there's any sort of follow-up points. So, so you asked some other questions. I'm going to try and pick up as far as we can those as we go through. So I think just by way of kind of introduction to your evidence, perhaps you could just summarise for us. I mean, well, firstly, how long have you been involved with this site and with these appellants?
I've been involved in the site since the early 1990s when it was an aluminium window factory and associated land. There have been gaps. I left Castle Point in 95 and didn't have any dealings with Glen Smith until about 2004.
And how often have you sort of visited the site, would you say, I mean, over that time?
About 20 times.
Yep. Where should we, what I'd like is for you to just set out a kind of potted history, if you like, of the proposal, thinking about the appeal site, and specifically that area of land that's not already part of the Manor trading estate. Kind of the history of what the proposals have been for development of that land from your knowledge and your experience, and kind of what the constraints and opportunities of the site have been, and kind of how we've got from early proposals to where we are now.
Okay. It really starts with the 2008 appeal, and rather, should I say, the run-up to the 2008 appeal, because the applications we formulated were sort of more 2006. I think the application was made in 2007, and as part of that appeal process, we had to assess the other land, because the triangle land, as we've been calling it, has a direct relationship with the other land, which now forms part of this appeal site. So we had various ecological studies of that, and really just sort of layered up a good understanding of the site, its locality and context. Good planning relies on good facts and good understandings, and various specialist studies are required. And I really present my evidence starting with the outcome of the 2008 appeal, and really the essence of that was to save local businesses. Kemp's were short of space, two other businesses were short of space.
Just Kemp's.
Sorry. So after Contemporary Aluminium, Unit 30 was bought by Kemp's. They were coach builders, and it was them that made the application in 1994 to improve their access and delivery. I was actually the case officer for that application. And the essence of the application was that it was a one-process building. They put in parts and components at one end, and sort of completely built-out coaches came out at the other end, and it flowed through the building. And the access road that was put in, and the access roads, the connections to the loading doors, were all part of the process. Part of the application then was to provide staff car parking on, I think, what we described as aprons yesterday. And then there was a huge area to the right, the area that is now we've been describing as the yards, and that was really an area that Contemporary Aluminium had just used as a dumping ground. It was covered in waste, and brambles and growth had come through the waste. And so what Kemp's did was they cleared it all up and they hardcored it, type 1, loose. And it was kind of an overflow area for them. The condition that was imposed was a precautionary condition, just to make sure that it wasn't used for anything other than storage and ancillary parking. But actually, I did the car parking calculations, and they could achieve it on the aprons immediately behind the building. So that was the substance of that. They actually went into decline. Glen came along, bought the building. They were retained in a smaller part of the building, but they then went on to have greater opportunities, but they couldn't fulfil those opportunities without then expanding again. And so we had this whole problem of the Manor trading estate, no room to grow, no space to go. And so Glenn tried to solve that with the 2008 appeal proposal. There was no involvement with the Manor trading estate roads. He didn't own them. There was no proposals on the other land within this appeal site. The very special circumstances were largely, can we save these businesses, please? We realise it's Greenbelt. That argument failed. The very special circumstances weren't deemed to be high enough. Kemp's went into receivership, never to resurface. It was suggested they could go to Canvey Island. I'm going to deal with barriers to Canvey Island later on, if I may, rather than here. So we learnt a lot, and the site went sold off on an option agreement, and some promotion took place in the background.
When you say the site was sold off on an option agreement, what are you talking about, the appeal site now?
Yes, Glenn gave an option agreement for others to promote the land for, I think it was 2 years.
So, and when was that?
Well, it ended in about 2000 and... Oh, my job number 16. Yeah, 2016. Because Glenn said, we're back on. We're going to promote it ourselves now.
Did anything, as far as you're aware, in those couple of years prior to 2016, did any kind of proposals come forward for developing that land as part of that option?
The option holders made submissions to the local plan process. And they were comprehensive submissions, including an acknowledgement that Benfleet scrap was noisy, which is kind of the obvious first observation. And what we did was we went about trying to understand the site in more detail. We knew as a constraint we had to deal with Benfleet scrap, both visually and orally. And that fact really occupied a lot of our early investigations.
I was going to ask you to check that the inspector's keeping up, because you're giving a lot of information.
Yeah, that's
and I know he's trying to write it down, so just to make sure that he's keeping up.
Tell you to go slowly if I can't keep up.
Thank you, sir.
What had come out of the 2008 appeal was, from our highway studies, was that there was queuing stress in Armstrong Road. So Armstrong Road is the main road from which you gain access and egress to the Manor trading estate. It has a junction with Church Road close to the traffic lights at the bottom of Manor Road. It's the only way onto the estate. We knew at peak times that even with the development of the Triangle land with our 2008 appeal, that was as much development as we could reasonably get out without causing queuing stress in Armstrong Road at peak times. So when we moved on to this scheme, we reassessed that, and we realised that in order to get the development out without having that queuing stress, we needed a second access. We had land which connected to Church Road, and that's why we have the Swan Neck access to the newly proposed access on Church Road. So again, that was a really important conclusion to come to, that we needed the second access. Then associated with that, obviously you've got then two very sensitive properties. You've got Robert Drake County Primary School on the Church Road frontage. Behind it you've got a daycare centre for adults with learning difficulties. And we were really concerned about the prospect of taking industrial traffic out on that road if it was in kind with the typical development that was already on Manor trading estate. We actually did discuss that with the school, and, well, needless to say, they weren't happy at the prospect. And so that's when we thought, well, maybe it could be B1 officers, cars and small vans, etc. So that was another part of the developing the understanding. And then I think really it was the opportunity to buy the roads, which was the next ingredient. And there are many ingredients, and they've all been difficult to bring together, and they've taken time. The roads, the ability to buy the roads, that was a complex 3-year negotiation which nearly fell apart several times. But it was achieved, and that was a little bit of a sort of a eureka moment for us, because we realised that in that came the opportunity to really align ourselves with the employment and retail needs assessment. Because I'd said to Glenn, look, if we're going to get planning permission here, we've got to align ourselves with the evidence base. We've got to we've got to follow the council's economic strategy and dovetail into it as closely as we possibly can. And there's never been any prospect of improving the roads. The 1998 policy just seeks environmental improvements with no mechanism to do it. Even the found sound policy EC1, it was the same thing. It was an aspirational policy. And I think one thing is, it's universal wisdom that you cannot expect different outcomes if you don't change your behaviour. And what Castle Point haven't done with their draft policies is change their behaviour on environmental inputs. What they need to do is align themselves with the findings of the employment review needs assessment. And so,
just to clarify, this roads and the negotiation, when are we, in terms of timings, when are we talking about now?
So the roads were, I've got date, the 30th of April 2019 was when the roads were secured. So there was a negotiation 3 years prior. The roads had been previously held by somebody who did nothing with them.
Just, are you aware of why buy them? What was the driver? Why was that done? Yeah, what was the purpose of buying them?
So that we can make a development that was sustainable, which dealt with the matters that the baseline reports had identified as being important, and really to have a deliverable, sustainable development. And now we weren't able to go public on any of this until we had the roads, because what we didn't want to do was prejudice anything that followed. We had our first meeting with the head of economic generation, Steve Rogers, just prior to it's the agenda is in my RF1. Just to give you the timing of it, 27th of June. So we knew it was coming. We hoped it was coming, and so although we hadn't gone into the public with any public meetings or anything like that, we were anticipating the prospect. So we got the meeting in the diary and started exchanging information with the council. We told them Benfleet scrap was noisy. They knew it was noisy. We reminded them about all the things I've just set out, really, all the opportunities and constraints. It was an open share of information. We actually said to them at that meeting, we're going to find out as much as we can. We're going to do all our due diligence, and we will share it all with you, and we did, all through those meetings. What we realised with the noise was that we would have to model it, and so this wasn't the first solution. I've got sketches in this book of early noise buns and the land take and the attenuation that they achieve. There was a whole process before we've got to where we are today, and the proposal you have before us is. It's been modelled to industry standards. It follows scientific rigour. It's not just rectangles on plans and noise contours made up. It's absolutely impeccable in the way that we've approached it. And I think it's wrong for the council to suggest that they haven't seen anything, that there is no evidence of scientific rigour. It's absolutely rigorous, and it stood up in this inquiry. And we knew it would need to. And the council were aware of it. We shared this with them throughout.
I think the point that was being made was, because obviously looking in 2018, you're talking about these meetings 2018, as we know, the proposed housing allocation, or the proposed mixed use allocation, the housing and employment allocation, was in a draft that was, I think, was rejected by councillors in November 2018. So I think what was being suggested was, well, you know, noise wasn't, when we looked at the SHLA and we looked at, you know, those documents, and, you know, no one really appreciated whether it could be acceptable from a noise point of view at that stage, because it was just a sort of first filter and that sort of thing. Is there anything you want to say about that, or about the proposal of the draft allocation and how that kind of came about as well?
Well, yes, I mean, when we first started, of course, the draft allocation didn't include housing. It was only as a result of our studies and our cooperation with the council that it was included. I think the other point is this: in the ERNA, it talks about it actually accepts in the ERNA that there is no quantitative need for additional employment land in the district till, I think, 2031. So that was the actual starting point in 2012. It's never been the case that the extension to the Manor trading estate was there to meet a quantitative need. But what the ERNA says is that if you're going to stimulate regeneration, you need to create a bit of space so you can generate new units and then decant and effectively create the circumstances for regeneration to take place. There are also barriers to that because the environment of the Manor trading estate is so poor at the moment, that depresses the rents. And so to invest in new build in a depressed environment that will also limit the rents that you get. At the public meeting, we had industrialists saying, I'm so embarrassed about the estate, I don't invite clients here. When I meet clients, I meet them elsewhere. Because in order to get to my unit, which is within the estate, I think one of them was on the northern edge, they have to come all the way through Armstrong Road, and he says, I'm just embarrassed. And I think they think less of me as a result. And they were the words of a genuine entrepreneurial businessman on the estate. And so improving the quality of the environment, making space for new units and decanting were all necessary to justify the investment in doing it. Now, our area of land is small compared to the numbers given in the ERNA, and which is another reason, because all these arguments add together. It's no one argument that's persuasive. You have to take it as a whole. We needed the higher value housing to be able to make this viable as an overall proposition, because there's a lot to do. Now, we haven't produced viability information. Glenn Smith is financially astute. He's run a specialist civil engineering firm doing railway engineering for many, many years. He understands spreadsheets and calculations and profit and loss and business like probably nobody else I know. He thinks it works. I've never had to provide viability information on a scheme like this. I normally only have to provide it. Anybody normally has to provide it if they're trying to get out of some kind of provision. You know, we can't provide 40% affordable housing because we've got this extraordinary thing to deal with. You know, can we have 20%? They're the normal circumstances for viability requirements. So we're content it's viable and it works, but each element of the scheme has been, has a contribution to make to deliver it properly.
Just before we move off of that point, there's the personal statement from Glenn Smith in your appendices. We've looked at a couple of times on other matters. It's your appendix 10. And I just want to invite you to look at page 6, the last page of that, and the conclusion. And yes. Whether there's is there anything that's relevant to this point?
Well, this is the point exactly. I'll just read it out, shall I? The LPA officers indicated that perhaps we can't deliver. We can, in truth. I was aggrieved at the undertones within the officer report. because I was too, there's some shocking cynicism in there. It questions our integrity. My track record proves otherwise, and I think that's true as well. It's not all about profit. £5 in for something that cost £1 that expects to spend £2 on regenerating the estate road still leaves £2 that can be used to build out the commercial element. But even at that, we've separate interest in the commercial. If we sold the commercial B2BA element at cost, we would still have £2. HMRC gets a proportion. It's always important. We might end up with £1.20. That's enough for me and us. So it works, but it's a very sophisticated, I keep calling it a jigsaw, an equation that has built up over time. And really, it's that sophistication that has been lost on the council in each of its local plan iterations. You know, even as an extension, just an extension to the Manor trading estate, and a policy that says we expect to see improvements to the roads. That really doesn't work. There's no delivery mechanism for the road improvement. You would get queuing on Armstrong Road because the highway reports demonstrate that. Council officers knew this. In our meetings, it wasn't just the head of planning, it was also the head of planning policy. You know, we had access to the best minds on the subject and those that were making presentations to committee. And if you would just say extend the trading estate onto the appeal land as proposed in 2014 and 2016, you'd have unimproved roads and you'd have dreadful queuing in Armstrong Road. So it's almost as if at every iteration, the information we'd provided, that fact-based scientific analysis, was being disregarded. We were quite pleased when the housing was added, because it suddenly started to align with all the understandings that we had about how the sites could work. Again, crucially important, the Swan Neck Road, the junction to Church Road, the recognition that you could wrap around Benfleet scrap and create an acceptable noise environment. But it still missed out the roads part of the equation. There was an assumption within the policy that would happen.
On the subject then of the roads and you know what could be done about those, we've seen figures of sort of 2 million, 2.8 million in some of the documents in terms of the costs of implementing that planning permission and doing those repairs that were discussed yesterday. And you've just mentioned about the housing and the value from that, kind of unlocking some of these points. I mean, why hasn't that work been done in terms of costs? How else will that work be funded other than through development of the neighbouring land?
Well, so can I just go back a step before that? Because I missed it out in my summary. Of course, we needed to understand what needed to be done to the roads. And so, again, we did a thorough study on that. We had a whole drone survey. We had, in fact, Glenn in his business was able to look at it and work out what needed to be done to refurbish the roads, to reinstate the footpaths, to guard the footpaths, to correct all the boundaries that have encroached onto the road over time, to look at the lighting system, to understand the drainage system, which is quite interesting. All those studies were undertaken so we could make a cogent application to remedy it sort of all as one. I'm just going to go to the inspector's question on this, is about did it need planning permission? I think the answer to that is arguably. It can be argued both ways. There are some permitted development rights. We wanted to put the matter beyond reproach, and so despite the fine line between it being permitted development or needing planning permission, we actually wanted a factual documentary record. We could have made an application for a certificate of lawfulness, but we opted to make a planning application because it also gave the planning authority the opportunity to impose conditions. We wanted to cooperate with them and give them some scope for control. So again, that all took place in, following purchase basically. So as part of that submission, there was also an estimate of the cost of repairing the roads, which I believe is £2.6 million. There is some income from the roads. There are covenants which are based on frontage. Roughly speaking, there are 100 businesses on the estate. Only 47 of them are subject to covenants. And the amount they pay is based on the frontage that they have to any of the roads. Now that's quite tricky because some of the businesses only have an access onto the roads and their yards or their premises sit behind the frontage. Others have a disproportionately wide frontage, but they're not very deep. And so in terms of the distribution of costs being equitable, it's hard to make that work. Benfleet Scrap, incidentally, only have an access. They've probably got the most traffic onto the estate with the heaviest vehicles, but the narrowest frontage. So in the last 3 years, based on their frontage, and I'll go to costs that have been expended so far, we would have been able to recover from Benfleet Scrap £217.48.
In that, sorry, the last 3 years.
In the last 3 years.
217. Yeah. Right.
So, do you want me to talk about what's been spent on the road so far?
Well, I suppose just covering it off. I mean, I suppose the suggestion has essentially been, the implication, I suppose, these roads have been in a terrible state for ages. Nothing's really been done, and you've got this planning permission, and you could have done some work and you haven't done it. And just in terms of the costs and what you've explained, do you think that's fair?
No, it's not fair at all. It's a complete misunderstanding, and I think it's just an assumption, not based on facts. These are the facts. £49,000 has been spent on the roads since they were bought in 2019. We've recovered £538 from the frontages in that period.
Are you able to give us a sort of
where
roughly? Don't go into huge detail, but kind of roughly what kind of works have been done and where have they been done? Because obviously, one goes onto the estate right now and kind of drives around. You can understand where the suggestion might come from that doesn't look like anything's been done.
I can give you the absolute chronology, but there are 59 gullies, that's surface water gullies, that pick up surface water on the estate. They were initially cleaned manually, and they've been cleaned annually 2 more times. So the gullies have been jetted out twice. The first one was absolutely dreadful. It was just, up to your shoulder in grit and dirt and filth. The consequence of the gullies being blocked, of course, is that when it rains, the roads flood. And of course, you then get that compounded with the rutting and the potholes and the mesh that's showing. And it just becomes an assault course. There were 75 foul water manholes. That's serving the foul water on the estate. They were inspected. There were 96 surface water manholes. This is infrastructure owned by Anglian Water. There have been 30 patch repairs in number. Those patch sizes range from 1 metre squared to 28 metres squared. There's been a total of about 100 square metres patching. But of course that's short-termism. It just deals with the worst excesses at any point in time. It's not a comprehensive relaying of the road. 18 metres of curbs have been relayed, 40 metres of bollards and handrail rail stroke pedestrian protection have been put in. And then I don't think the inquiry's aware of the backup power generating plant which sits to the north of 30 Brunel Road. That's on G&K's land. That's a 14 megawatt backup generator, gas generator, which keeps the lights on in South Benfleet when there's power fluctuations. But in order to install that, there had to be way leaves granted through the road system. So here again, you understand why G&K, why Glen and Act Roadways bought the roads, because without owning the roads, they couldn't put the way leaves in for the power generating station. And so there was a big dig out, 306 square metres in Parsons Road, 115 square metres in Fulton Road. We can take you to these on the site visit if you want to see them in practice. These are actually acts of regeneration which are being undertaken at a level that's affordable in the absence of no other income from development. And what you have is a state-of-the-art power generating station on the estate that wouldn't have been there otherwise were it not for the tenacity and business acumen of people like the appellants. So they're the roadworks. I can give you the chronology. There's been another drone survey in January 2023 so that we can monitor the condition of the roads.
We saw some of those pictures in Justin Bass's appendices yesterday, didn't we?
And incidentally, in the cost sheet, there's a liability insurance element of £844 a year.
Is that relevant to the point that was being put yesterday about, because the road's in such a terrible state, if somebody falls over, they're going to sue you, why haven't you done anything, essentially?
That and the localised patching regime, yes. Mm-hmm. I mean, they are a liability, there's no doubt about it, prior to this, and I'll perhaps just finish with this, before this was on the table, the previous owner tried to get together with Glen to do with the development to the north, and they offered to relay the roads in relation to that development, and to then transfer the roads to Castle Point Borough Council for £1. Again, that was in meetings with, at the time, it was in this room, the Director of Planning, Ian Birchall, who was the director here for a long time, and the council just flatly weren't interested in having any ownership or responsibility in relation to the roads because of the liabilities involved in owning them.
And when was this, roughly?
Well, all I can say, it was pre my 2016 involvement. It was early. The Hickforth scheme is also with the Hickforth scheme up at the A127. I don't know. It's
all right, but we're talking
prehistory.
Yeah. Okay. Just sticking with the roads for the time being. Still, see, there's the planning permission that's in place, and
yes,
we know, we'll look at it later, the Section 106 agreement would secure the implementation and delivery of that planning permission. Now, a point that hasn't come up yet, but that planning permission obviously has the usual time limit on it, and it's due to expire, I think, in July. It's got some pre-commencement conditions.
Yes, it does. Yep.
So, the inspector might be thinking, but that's not very long. Am I going to, if I grant permission, is this just going to kind of fall away? What's the plan? Yeah,
well, that planning permission sits in our project plan, and has done for a long time, and we were quite aware of the dates, and obviously we have to align any action we do with the appeal process, or what was the application process and now the appeal process. We anticipated actually that the inquiry would be later than this, and so we just thought we would renew the application. But actually the timing has changed our plan on that. My colleague Kieran, who works in the background, sat there. He's in the process of putting together a conditions discharge application, which I think we've scheduled to submit at the end of the second week in March. There are only two pre-commencement conditions, Condition 2 and Condition 7. Condition 7 requires, and perhaps not verbatim, but further information on the surface water and foul water systems, including CCTV. Now, obviously, we can't CCTV survey Anglian Waters drains, but we can survey all the connections to that from the gullies. which we're in the process of doing. It's an easy process. We're familiar with CCTV surveys. That information will be ready. Condition 7 is a construction management plan. Construction management plan is an everyday occurrence for a civil engineering firm, and Warren over there, he's putting that together as he has done on previous projects. That'll be ready to go on the second week of March. Those conditions probably benefit from deemed discharge, so we can guarantee an outcome even if the council dilly-dally on determination. So we'll have a determination mid-May, which then gives us 2 months to implement. G&K Groundworks are on site. They know what they've got to do. They will at least perform a material operation, and that planning permission will be preserved.
Thank you. I suppose while we're still on the roads, then there's some points that came up yesterday, sort of concerns about. This is specifically in relation to parking. Well, perhaps actually before we do that, in terms of parking, because we obviously know at the moment there's parking on footways and parking on corners, and Mr. Bass dealt with some of that yesterday, and he alluded to the potential within that planning permission to use the road markings, which are part of the planning permission, to essentially implement some measures of control for parking. He talked about possibly parking on the carriageway might be acceptable, and we also looked at the covering letter, which talked about kind of broader intentions for kind of parking control beyond that. Do you want to just comment on what the intentions are and how that would kind of fit in with the planning permission?
Absolutely. I mean, I think there's been a wholesale misunderstanding of the massively positive consequences of the roads regeneration scheme. There is going to be some adjustment of behaviour by occupiers of the units on the Manor trading site. There has to be. They've encroached on the roads. They've taken space to, well, I don't know, use it however they wish. And they've been allowed to do that because nobody seems bothered. Skips are left on the road. Containers are left on the road. Parking is entirely indiscriminate. Nobody has a right to park on the road. They have a right to pass and to repass. And that is all. So when the roads are regenerated, you'll have a clear carriageway, you'll have clear footways. People won't be able to park on footpaths. I heard that as a criticism, really, but actually people should never park on footpaths. People need to walk to work from the nearby residential area. They need to be able to cycle to work from the nearby residential area. They need to be able to do that safely at night. There's only, is it 1 or 2 working lights on the estate at the moment? The regeneration scheme will create a massively safer environment, a more free-flowing environment, and it will curb the bad behaviour of those who park on the roads, park on the pavements, leave their skips on the road, leave their containers where they like. And I don't think that should be underestimated by any means. I think some people will have to think about how they organise their businesses in terms of the external spaces. But that's not a bad thing, because what's happening now is absolutely dreadful. If you go to Unit 30, it's the best presented unit on the estate. It's got the best road outside it. It's got the clearest footways. It's got marked out parking. If tenants leave waste, they get told. And that's how businesses should be operated. And in some way, I'm suggesting a fairly large way, the existing businesses will need to adjust their behaviour as a result of the improvements. And it might cause a little bit of pain for some. But I can tell you from the public meeting, there's more people interested in the positive improvements and who want to be proud of their businesses, who want to raise their game, than those who will perhaps complain and balk against it. It's a complex equation, and we're doing it gently and professionally and with good intent. So in terms of the parking regime, there is scope, I believe, within this appeal to, again, we want to involve the local authority to have a regime of traffic management and parking that operates on the estate roads. Now, we've not put it forward. The reason we've not put it forward is I believe something like that requires public consultation. I think if you impose a regime, then that's not the right way to do it. People will have opinions, and some of those might be good opinions, and there might be things we've not thought about. So I'm suggesting that there's a condition relating to traffic flow and parking management. I mean, there's another sort of question in the background, and that is, what do you do about the 53 businesses?
Before we move on to that, then, this condition that you've just mentioned, firstly, have we got any wording on for that?
Yes, it's in the draft conditions.
We've got a condition in the draft
We
conditions.
added 2 conditions to the LPA schedule.
So we'll come on to that. Now, a point that might be made, because it's already been alluded to in relation to the roads, and perhaps we'll deal with this first, or maybe we can deal with them together. A point that's made in relation to the roads is, why is it necessary? Why is it appropriate? Why is it fairly unreasonably related to the development to require, as part of the planning permission for this proposal, all of the estate roads to be brought up to standard? Why don't you just, for example, bring up to standard the bits of road that might be used to access? And so one can imagine, aligned with that, in relation to this condition that you've just put forward, a similar point would presumably be made. Why, for this development that we're proposing with the area of employment land that it has, would it be reasonable to have a condition requiring a parking or a traffic management scheme for the estate road? So do you want to give your view on that,
I
please?
think the first point is that the overall proposal is holistic. The roads proposal and the appeal proposal read together as one. Had I anticipated that as a criticism, I might have simply included the roads in with this proposal. But we wanted to make sure that what we were proposing in the roads was acceptable in the first instance, if you like, taking baby steps. So it does sit as a separate application. But I do maintain that the condition of the roads and everything that means is fundamental to the delivery of the council's economic objectives for the Manor trading estate, and therefore should be included. And I do think it's fair and reasonable to do that.
Just thinking about, the specific suggestion of, traffic might only use parts of it. I mean, would there be, if the new employment land is developed, would traffic only be able to go via a certain route, or could it use any of the roads in the estate?
We have discussed options. I mean, one of the options is to have a one-way system, because if you have one-way system, you could then give some of the, because you haven't got two-way traffic, you could then use some of the spare capacity within the carriageway for on-street parking, but to do so in a controlled and managed way. So yes, it's an option, and there's a lot of merit in it, but then that's just one of other possibilities. We want to hear what the other industrialists have got to say, and the council, of course.
Right, just coming back to kind of employment and qualitative improvements, and you've alluded to the earner, and we've looked at that. Whether we need to go to it again, I'm not sure. But I mean, obviously that date's from 2012. And then we've got the Seedner, which I think is 2017, if I'm right.
That's correct.
But it's later. I mean, it might be thought, and I think it was possibly suggested yesterday, that's an old document. To what extent is what's said in that document that you rely on still relevant now?
No, absolutely. The Seedner doesn't supersede the earner. So that's the South East Essex Development Needs Assessment of 2017. Doesn't supersede the Employment and Retail Needs Assessment of 2012. Are you happy with me calling it the Seedner, or do I have to give it its full title every time I mention it?
I imagine the inspector's able to understand what you
the 2017 document qualifies where it sits in the hierarchy of documents. It says, for Castle Point Borough Council, the existing employment and retail needs assessment of 2012 provides the economic and employment evidence base for their new local plan. This employment development needs assessment, the 27 document, complements the existing assessment and provides the strategic level assessment within which its more detailed assessment of employment sites sits. So the 2012 document comprises the more detailed assessment of employment sites, and nothing has superseded that. And actually, the council's economic development strategy still sits in 1998 with the adopted local plan. There was an employment and retail needs assessment in 2006. That's the one that informed the 2008 appeal. I've referred to it to some extent in my evidence as to describe the journey. But that 2006 document feeds very logically into the 2012 document, which is the last word on the matter. There isn't a more recent document. The council hasn't commissioned it, and none of the things it recommends has really come to fruition. You know, the council has delivered now for the first time in 24 years. It started to deliver its 1998 allocations on Canvey Island, but it's only partially delivered them. And if you go down there, you're not getting industry, you're getting trade counters and retail warehouses. And so the 2012 document is very much up to date and still fails to be delivered. And in a way, and I'm really almost shocked and surprised at this. I sat in the local plan examination. I had my 10 minutes to try and explain everything I'm explaining to you now in the context of, is the plan sound or not? So I had my work cut out, and I really just described how sophisticated our proposal was and how what was being proposed in the local plan was not deliverable for all the reasons I've explained today. The inspector didn't accept that. I can't change that. But I think where the inspector went wrong was he simply didn't accept or look into the qualitative arguments at all. You know, the earner of 2012 starts out by saying there is no quantitative need for new employment development in the district. So we knew that anyway. But then it spends a lot of time talking about why we need qualitative improvement so that we can retain those family-owned entrepreneurial businesses that want to stay in Benfleet, that have got all their staff living locally. And I've heard it too many times now, people coming and assessing this situation and saying they can go to Canvey Island. Well, I'd really just like to say a little bit about that. The development that's just taken place on Roscommon Way is 100 metres from the seawall. Canvey Island, in large part, sits below sea level. People are concerned about flooding, rightly so. It was drained by a series of ditches which flow out to the sea. There's a little bit of attenuation on the island, but not that much. And if you get a combination of high tide and high rainfall, what happens is the tide prevents the surface water discharging out to sea. The small amount of attenuation fills up very quickly and has got nowhere to go. So large parts of the residential streets, they sit under 6 to 8 inches of water because the surface water goes nowhere. Now, the second barrier to Canvey Island is its road system. It has 2 roads onto the island, one at Benfleet Station where the old stepping stones used to be, and Canvey Way. But they both go through one roundabout. So if anything happens on Canvey Island, you've got to go through Waterhouse Farm roundabout. You can't get off the island. The third objection is this. I could show you on an aerial photograph, or if we drive down there, it's easy to see. That end of Canvey Island is an industrial wasteland. You've got the abandoned oil storage infrastructure from the 1970s, where there's no mechanism to remove it. You've got the gantries coming in from the River Thames. About 400 metres to the east, you've got gas storage with nothing in between. And the cordon sanitaire for that gas storage, particularly for residential development, is huge. So you're within 100 metres of the sea with surface water issues and a potential breach of the seawall. You're within a line of sight about half a kilometre away from gas storage, and you're surrounded by the industrial wasteland of abandoned oil storage in the 1970s. But actually, the most striking thing as you drive down onto the island is you see the oil refineries at Corriton. And I say to people, what do you think you see when you drive down Canvey Way? They say, oh, it's all those oil refineries on Canvey Island. I said, they're not on Canvey Island, they're across Benfleet Creek, they're actually in Corriton. But they're abandoned now too. So that just adds to the general industrial malaise that surrounds this part of the island. But they're not the best points. If you drive from Manor Trading Estate down to Tarpot and you're on the A13, now that road leads straight into London and you don't get a traffic light until you're almost in the city. It's a superb road into the city. You get to Sadler's Farm roundabout, which is that weird roundabout with all twists and turns and traffic lights on it. If you get to that roundabout and you wanted to go to Canvey Island, you have to turn left down Canvey Way. But if you go straight on the A13, you're at Basildon before you would have got to the bottom of Canvey Way. Or if you turn right, you get to the top, because Basildon is sandwiched between the A127 and the A13. So you can get to Basildon quicker. Basildon's hasn't got all those constraints that I've just described. It's actually got cheaper floor space because they've got, to some extent, they've got an excess of floor space if you read the reports. And so the net effect is that if you say they'll go to Canvey, they won't go to Canvey. Even the report says people who live on Canvey will work on Canvey. But actually, if people are forced to go away from the north of the district, they'll end up in Basildon or Southend on the 127. And so you lose them. And that has been the facts. And the final point on this is that history tells its own story. The council allocated those sites on Canvey Island in 1998, so we were thinking about it in the early 1990s. They're only just coming on stream. If you look on the proposals map, Ross Common Way, where that new build has taken place, what the earner tells you, or it might be the Seedner, was that Ross Common Way was put in by the East of England Development Agency. So no developer provided that. But what the East of England Development Agency didn't do was they didn't do the next bit that's on the proposals map. So if you go from Haven Road across the southern part of Canvey Island, what was meant to be the Southern Relief Road, it's still not in. And it probably never will be in, because I don't know who's going to finance it. And then we've heard about this technical start on Northwick Road. We can go and look at that junction. I've got over 1,000 planning permissions over the years through various means. But I could say I've probably got 30 or so technical starts on my books. I've got hotels, I've got industry, which for whatever reason haven't started. A technical start is not an indication of any will to actually fulfil a development. All it does is it preserves a planning permission and saves the trauma and cost of having to have a second go at it. So I think the technical start can be discounted.
Can I take you back to the earner?
Yes, please.
And I just want to read out a paragraph which I read out yesterday and ask you to kind of elaborate on how it's going to work in this case. Now, as you said, indicates a quantitative supply of industrial space. And then the paragraph from the executive summary, which I read out yesterday, it's the inspector's reference, it's PDF page 8. Says, despite the surplus, there may be a qualitative need for some more sites that are readily available and better located to strategic roads and population centres in the north of the borough. I think that's the point you were just making, essentially. such sites might also have better prospects of attracting developers than this. They could also enable the decanting of firms in established industrial areas and modernisation of the stock in the older areas. Now, obviously, we've had some discussion already and kind of touched on it yesterday in terms of decanting and, you know, the pump priming idea and how this might how the delivery of these new B8 and B2 units would potentially start a process of decanting and that might kickstart regeneration. So, and there was criticism of essentially a lack of evidence of this, suggested that, you know, should we have illustrative plans, should we have consent of landowners, that sort of thing. So can you just explain for the inspector how that process is going to work and how it can work?
Certainly.
In this case.
I'm referring to Plan P205C, which is the
master plan.
The latest iteration of the master plan.
Yeah.
And I'm also looking in Appendix 2 of Alison Hutchinson's proof, just for the sake of having an aerial photograph there.
Which particular one should we look at?
I'm just looking at the first one, December 1999, but it could be any of them really.
Okay. Just to show the area, so that's the point.
Yeah.
Yeah, go on then.
Can I say we had a very detailed plan in 2008, but that was to those specific users, and there was a slightly different configuration. So the first building to be built would be Building B on this plan. That's the southernmost building, washed blue in the triangle land. It runs along the northern boundary of Benfleet Scrap.
And that's the one indicated as a B2.
Yeah.
Yep.
So that would be the first building to be constructed. Now, if you look on this plan, you can see the angle of the triangle and how it relates to land within the existing site. So in building that building, none of the yards to the rear or to the east of Unit 30 would be disturbed. G&K, bearing in mind the family members are all in their 60s now, they're not the big firm they were, and they have this property portfolio. So they're a small operation, and they will occupy a small part of that building, and they will take with them some of the businesses that are already existing in either Unit 30 and or the yards, because you'll appreciate companies like Benfleet Plastic are dreadfully fragmented. They've done a study that if you look at the workshops and the offices and the yards that they occupy, they could actually, I think it comes to about 12,000 square feet. They could probably the inefficiency inherent in that, in going from one premises to another, is huge. They think they could probably operate on a much lower floor space if it was a modern building, decent ceiling heights, and convenient servicing arrangements. So some of the existing companies would come in. If you actually look at Building C, which is the obvious next one, that's actually also outside the triangle. Now, it's possible that the first of the yards within the existing estate, closest to the northwest corner of Building C, may be affected, but that yard is G&K's yard, so again, no consequence. So you can then take in other businesses, whether it's from Unit 30 or from elsewhere. Obviously, we'll have to wait and see on that. We haven't formed an orderly queue at present, but there is certainly a semblance of a queue. And by the time you get to Unit D, I think the whole nature of the yards and this idea of displacing them will have gone away, because there are no sitting tenants, by the way. I think that was a point for yesterday. Everybody has leases with reasonable notice periods. And actually, and I know you can't tie this in as an aspect of control, but Glenn's history is looking after businesses, not kicking them off just because he's got a better idea. I'd actually like to give us an example. If you look at the land to the north of Unit 30, I'll go to so if you look at the June 2018 aerial image, there's a whole open yard to the north end, beyond the north end of Unit 30. Now originally that was divided up into 5 yards. Marden's had 2 of them. The training company had 1 or 2 of them. There was a 5th person. I understand the 5th person went bust, but obviously Glenn was negotiating with the energy generating company, and if you go to March 2022, you actually can see that 14 megawatts gas generating plant in place. And you might ask yourself the question, well, what happened to those 5 yards? What happened to the proprietors of those businesses? You know,
what happened to any parking that they might have been doing?
Yeah, exactly. Yards? So Marden's rationalised their business to some extent. Their business is located also at the southern end of Unit 30. They also took interest in another building on the estate. And the other occupier was assimilated into the yards on the east side of Unit 30. So each of those business operators wasn't pushed around and told to go and don't come back. They were cared for, and they adjusted their businesses to suit the circumstances. And apart from the one that had already gone bust, they're all still trading, but obviously within the limited confines of what the Manor trading estate can offer. And that's the same that will happen here, except in this case, we've got plenty of scope within the triangle land to actually make the provision first and then move it around.
I mean, I think we're basically on the parking displacement point at this stage. And just to kind of covering off on that, just from your own knowledge and experience, obviously you told us how long you've been going to this site and known this land and been visiting. In terms of the use of that area where those yards are, is that a parking facility?
If you look at the rating, they're storage and premises. They're all storage and premises. I think it's fair to say that the people who have those yards use them as they see fit, but I think the predominant characterisation of that is open storage. There is a parking area. That was a facility that was provided for. There's a club in Unit 30, and they're allowed, and that was provided sort of for after hours really. But in terms of how Unit 30 works, I mean, after Kemp's went bust, the rates were horrendous. There was no tenant. It was a really bad time, and what G&K had to do was they broke the unit up into individual units. They provided more parking at the front. If you go back on aerial photographs at the northeast end of the building, it was there wasn't any parking there, and when you look at it on site, the land levels are tricky. But Glenn engineered a parking solution there, so every unit has parking at the front. It also has the aprons at the back, and how they use those aprons is up to them. If they need it for parking, they can use it for parking. If they need it for storage, they can use it for storage. The vehicle identified in Benfleet plastic that they go over to the yard to load vehicles up.
Is this the one that we looked at yesterday
Yeah.
in Ms Hutchinson's appendices? We could see the timber yard, and there was the truck parked there.
That's
I
right.
think it was being suggested. Well, that's parked.
Well, they drive trucks into the yard to load them up. It's kind of logical, really. You wouldn't carry the timber from the yard and take it over to the back of the building. That's just in terms of work studies and efficiency, it's a ridiculous notion. What Benfleet Plastic do is they put all their vehicles into their unit at night for security. And I mean, I've made this observation before. There are no better parking arrangements on the Manor trading estate than around Unit 30, because it's managed properly and provision is there.
I'm just going to read out that bit of the decision notice, the reason for refusal. It says further, it's not considered the applicant has adequately demonstrated the proposed development will adequately mitigate its impact on the existing parking provision within the adjoining industrial estate in order to ensure that existing operations are not compromised by the proposal. Do you think that's made out?
No, not at all, no.
So on the decanting, you kind of explained the process and how that would work and how that would relate to the yards and this suggestion of displacement. It's obviously relevant as well to the kind of regeneration benefit that the appellant is advancing. This idea that, if you may kickstart a process, so if you put this new space in, people will move into that new space, that will then free up the old space, then that can be redeveloped, and you have a sort of cascading or a domino effect.
Okay, yeah.
The point being made that there's not really any evidence of that. We've seen the earner and how it talks about that, that process. What do you want to say about the evidence for that?
Well, the first thing about it is the evidence is in the earner. That is what it says in terms of how they anticipate this might happen. And it's not as if this is all taking place behind Unit 30. It's why the improvements to the road system are really, really important. I don't really want to sort of go over old ground, but fences that are on the road at the moment are going to get moved back. Parking that's on the road is going to be rationalised within, so the whole estate will get a facelift in all kinds of different ways, and hopefully, because you can never do this in a situation unless the Castle Point invokes some sort of compulsory purchase powers, which are overarching, which isn't going to happen. All you can do, and I keep using the phrase, is to create the circumstances. Now, we're going as far as is possible within our ability in all the ingredients we've put together to create those conditions. And I think when people see the improvements to the trading estates, bit by bit, in lots and lots and lots of small ways, they will take heart, and they might replace their windows, and they might replace their own cracked hard surfacing, and they might actually do something with the waste that's sat in the back corner, because some will begin to care, and some will also realise that it's improving the value of their properties, and it's improving the value and the attractiveness of their businesses. So they'll be more effective businesses, they'll be in a better place to actually invest money, and so lots of things could and probably will happen as a result of it. But no, I don't have absolute control of it. Mr. Smith doesn't have absolute control. But my goodness, Castle Point has never seen anything like it. And if this goes away, they'll never see it again.
Right. Is there anything else you want to say about employment? We spent a long time on it, and I was going to move on to a couple of points about housing and some other matters.
I feel as if I've said quite a lot.
Yeah, you have. On the house, a couple of points on housing. I think really probably just one point at this stage, the affordable housing. And we looked at the Chelmer Housing Partnership email yesterday, and the point was made, that was in 2021.
Well,
how do we know whether they're still interested?
Well, that email was part of a chain, and I had the rest of the chain. But yeah, I mean, it was refreshed in January this year.
When you say it was refreshed,
Well, they're
what
still
do you mean?
interested. They're still interested in the same way.
And are you indicating there that there's an email
Yes.
that we
yeah.
can? Okay, have you got that with you now?
No.
Is it something we can provide if
It
the
is,
inspector
it
wants
is.
to see it?
Glenn was
can you
meant to
provide
bring it, but he forgot. He brought some other things, but he didn't bring that.
Right. Well, so would you like to see that? If we can get hold of it.
It's up to you. It's your case you're presenting.
Well, I'll if we can get it, I'll ask if you will accept it. We'll see if we can get hold of it.
We'll have it before the end of the day.
Okay. Can we have it by lunch? Thank you. Okay, couple of other points there. Benfleet scrap. Just a couple of points on this. We've heard quite a lot about it already. Yeah, we'll get it later. Yeah. Okay. Factual point. There's an issue about whether there are 3 or 4, whatever you want to call them, grabbers, excavators. I'm not sure of the technical term.
Being chased by an invisible fourth grabber.
From all the times you've been on the land, what's your evidence on what you've seen, what you know to be there?
It's 3 grabbers. I've been through all my photos as well. It's 3.
Okay. Now there was a point made in Ms. Nixon's evidence about, you should have engaged with Benfleet Scrap. Why haven't you gone and asked them about their operations and how they operate and what they're proposing to do? And I'm not quite sure what exactly information was supposed to have been got, but there was an answer to that from Ms. Nixon referring to kind of judicial review, and essentially she was saying she'd effectively been advised not to speak to them. Is there anything you can sort of elaborate on?
Yeah, absolutely. Yeah, I mean, if you look at the photos in my appendix RF, these are photos taken in 2018.
These are the ones that show all of the waste spilling out the edge and the
boundary.
Broken fence and so on.
A clear pollution problem, oil puddling, engine parts, all on the appeal site. Subsequent studies have shown that it's massively polluted by things that you wouldn't want your children eating. So as a result of that, we took it up with Benfleet Scrap. They denied it. And actually, this is the essence of the wall application, the one that went to judicial review. I prefaced my objection to that by saying, we're happy for Benfleet Scrap to operate as long as they do so within reasonable controls. But for goodness sake, the land is seriously contaminated. And the box on the form that says, is this land contaminated? It says no, or whatever the way the question's phrased. And there's no study. I brought that to the attention of the council. The council ignored it. They determined it anyway. Benfleet Scrap were allowed to continue and have their application determined. And we simply said, and this was the essence of the judicial review, I advised on this in conjunction with solicitors, that the council didn't take into account something they should have taken account of.
Let's not go blow by blow through the litigation.
I'm stopping there to simply say we had to instigate legal proceedings against Benfleet Scrap.
Is this separate to the judicial review now?
Yes, for contamination trespass. Now, those proceedings have only just completed, and whilst we were in litigation with Benfleet Scrap, incidentally, their boundary markers are also in the same position. We've had to force them legally to move their boundaries. So we've been in very expensive and difficult and tense litigation with them for some period of time, and it's only just coming to an end. And so asking Josie Nixon to go and have a chat with them about noise levels probably wasn't a good idea.
And then just this point about which you make in your proof of evidence about how, the suggestion is they're operating outside the terms of their permit. They're operating in kind of irresponsible manners, not essentially not complying with kind of best practice. What do you want to say about that?
Well, that's categorically true. I mean, I only make a small point of it. As a matter of fact, it's true. I can't remember exactly what I said in my proof. I can turn it up, but almost every time I've been, the scrap pile is over 5 metres. And it's easy to work out because the eastern boundary is 5 metres high now. The northern boundary is 2.75 metres high. And if you take a photograph, you can just work it out by proportion, which is what I did in my photographs. And it's like that commonly. They've been told that in some of their EA reports. So again, that's a matter of inspection by the Environment Agency. And they've also been told to, and this is a best practice point, not to drop waste, not to drop scrap. So if they're dropping scrap,
When you say not to drop it,
so they pick it up, they're to place it rather than to drop it.
Right.
So that it's placed onto the scrap that's below it. So they're dropping from too high onto scrap that's too high. They're dropping into containers rather than placing from time to time. That's just a from time to time point. And the height thing it's fairly consistent, to be honest. And all I'm saying is that gives a false baseline in terms of the studies. And in terms of the balance and how you regard the noise conclusions, there should be an adjustment for that. I don't have an axe to grind against Benfleet scrap. I appreciate that they should operate within controls and that should happen. So that's really the extent that I take up that point. There is one other point to this, and again, it's the obvious point. You go there, you think, oh, that's noisy. It's just a logical, I can understand, but that isn't really the conclusion. That's the beginning of considerations. I went there and I thought, oh, this is noisy. What are we going to do about this? And I thought I would really say to Castle Point Borough Council, we have some concerns about the noise. We'd like you to investigate it. What are you going to do? If anything, really, I wanted to know what the council's response was, and that's where I started in 2018. And you've seen my letter to the council. I don't know if they investigated it or not, but it was addressed to the enforcement officer under the planning permission, which has a noise condition, and the environmental health officer, because it's obviously an environmental health officer point. The fact is, they're not bothered, and there's only been 15 complaints or so over that time, and those complaints are imprecise, not persistent, haven't resulted in any statutory action. So Castle Point aren't bothered either at the planning or the environmental health level, and the complaint record doesn't indicate that there's a problem. And we've modelled it in any case and have demonstrated we can create a satisfactory noise environment, which for the existing noise sensitive properties, that's a primary school, a daycare centre for vulnerable adults, and the people who live in Keswick Road who've never complained once. We're going to improve it for them, and the people who are going to live in the houses we'd like to build, they're going to have a much better noise environment than the people who already live there who aren't complaining.
right. Just briefly on the restocking notice. Can we go to core document CDK 15, which is the letter?
I'll have to put my password in because I've not used this yet this morning. Sorry, can you give me that reference again, please?
Yeah, K15.
Oh, yeah. K15, yeah.
Yeah.
That's Glenn's letter
this
to the...
is the letter in response to the final restocking notice issued following the appeal. And what I really want to draw attention to, and for you to just explain briefly, are the plans that are attached to that. And what they show, because I think the point that's being made or will be made is that that restocking notice effectively, because of where the trees would need to be restocked, shown on the plan, is effectively going to prevent delivery of this development, or in particular the Class E buildings which contain the noise or the proposed noise attenuation, and that therefore the inspector should give that quite significant weight. So can you just take us through, probably it's just those first two plans, and just explain what they show and what conclusions you draw from that, please?
Sorry, I just need to get the plans up. So K11 is the first.
You're going to them separately as core docs, so you'll.
Well, they're just better quality.
Oh, okay. They're attached to the back of the letter, but I think they also have been added in separately as core documents with their own numbers. So I think they're the same plans.
They are.
Whichever reference you want to look at them.
But they were reduced to be attached to the letter.
Right. So which one should we look at?
K11
K11
is the first one.
Okay.
So what we did with K11 is we overlaid the badly drawn stocking notice plan, because it was a sort of a hand drawn thing, and we overlaid it on our master plan, and this is what this plan shows. So you've got the 4 areas numbered 1 to 4. We've added in that area 2 is in contaminated area. I don't sort of say any more about that in relation to your question. And then if you look in the bottom right hand corner of that plan, this is really quite a helpful schedule. It numbers the patches, and it gives you the area of those patches. So patch 1 is 675 square metres, and it gives a total of 3,003 square metres, 0.34.
Yeah.
And now you have to read this plan in relation to the reference committee's findings, and they said that at the density they require, that's on a 3 metre grid.
This is in core document K3, the reference committee report. I think you're referring to, perhaps I'll just read it out to save time, paragraph 22, where this is in their conclusion. The reference committee concluded that a modified restocking notice should be issued based on the trees explicitly identified, 61 in total, at the ratio 3 to 1. This means that at least 183 trees should be planted, evenly spaced at normal 3 metre spacing, i.e. 1,100 stems per hectare. This would amount to an area of 1,647 square metres.
That's correct. So on that table in the bottom right hand corner, we've added that in, 1,647. And what that shows is that the patches shown on their badly drawn plan and the actual area required, there's a discrepancy of 1,356 square metres. To the bottom left of that plan, we've just put in an indicative 3 metre grid just to show, what sort of density that would look like in accordance with normal sort of planting requirements. So we produced a second plan. That difference, by the way, is 82%. Those patches are 82% bigger than they should be. So we produced an adjusted notice area plan, that's K12.
Yeah.
And what you'll see is we basically shrunk the areas by the if you like, the error. And okay, we could have shrunk them in different ways, but we tried to do it in a reasonable way to maintain some kind of integrity to those areas. But we shrunk them nonetheless, and that's what you're looking at there. The dotted black outline shows the bits that are in excess and have been taken out. And so you get areas which are a lot smaller than shown on the Forestry Commission restocking notice plan.
So the restocking notice itself doesn't refer to any particular area. It refers to the number of trees, the 183 trees and the spacing. Looking at K12, is the conclusion you're inviting the inspector to draw from that if you were to comply with that notice and plant 183 trees at that spacing, which we know from the reference committee would take 1,647, that those are the areas that would you would comply with the notice by the point those areas shown on K12 were filled.
Absolutely, yes.
And what implications does that then have, do you say, for the, bearing in mind it's illustrative, but what implications does it have for layout in the master plan?
Very little.
How do you say that? Because, I mean, clearly we can see...
Well, because that was just one way of doing it, the way we did it. We probably went through 3, 4, 5 options before we even got to that. Okay, we've got a new constraint, but it's a relatively modest constraint, bearing in mind that what else if you go to plan K14, because this is the other thing we said, well, okay, let's look at our plan, see what open areas we've got, and that's what K14 is. We've just gone to all the green spaces within our ownership and control, and so that we don't conflict with the numbering on the other plan, we've called them A to G. We've totaled them up, and they're 6,692 square metres, and we can move them around. I mean, I appreciate that when you move one thing, another part of the equation changes, but that's not within the wit of man to sort out. It's just an adjustment to the layout, and we'll move the component parts around. We'll make sure that we don't create a worse noise environment, because obviously there is some shielding of buildings. We understand all the issues, and it's just a little bit of master planning.
That final point, I think the suggestion is essentially accommodating the restocking notice areas within the proposed open areas. Of course, that would depend on the restocking notice is what it is, and we've had an appeal. So that sort of further step would require negotiation and agreement from the Forestry Commission, would it?
Yeah, it would. I mean, I think the path of least resistance is just to work to the adjusted plan, and just work around it.
Now, one short question the inspector asked yesterday was about the reference committee and whether they were aware of the development proposals, during that hearing. You were at that hearing, were they aware?
Well, yes, they were aware it's being promoted through the local plan. All they said was it's a draft plan, it's not been adopted, and it's immaterial to our considerations. So we got short shrift on that. And similarly, the proposals and the application, same thing really. It wasn't material to their considerations. They weren't interested.
Okay. Right. We're nearly there. I just want to go through the balance and kind of waiting for various harms and benefits with you now. Unless there's anything else you want to say of substance, I think we're just going to conclude with going through the benefits, hopefully, and the harms. So in terms of Greenbelt, you've set out in your evidence openness. You've gone through certainly the visual side of things in your proof already.
Yeah.
What level of harm to Greenbelt openness do you say that would be caused in this case?
Well, I just agree with the part 2 of the Greenbelt review. It's
that was dealing with purposes, though, wasn't it?
Oh, sorry. Yeah. Okay. I think it's fairly minor, really. I think the only point that has changed my perception on that is the fact that they stripped out the understory on Windermere Road. I've been up Windermere Road many times over the years, and that's just a visually impenetrable woodland, and always has been up until the understory was stripped out. But it'll come back, and it was only stripped out as I'm surmising here, as a response to the TPO. The council put a load of TPOs on around the periphery, not in response to what our side. They just did a few at the same point in time, and it was immediately following that the owner of that woodland stripped out the understory. Don't know why, but it'll grow back. But that's the only. Because I said I think it's visually impenetrable, or you can't see. I accept you do get glimpsed views through, but you won't as a matter of natural regeneration of that woodland.
And obviously that's visually, but there's also the spatial element of openness as well, just the pure replacement of open land with built development. So kind of taking those two aspects as a whole, what conclusion do you reach on harm to openness?
Well, I think it's moderate.
And then purposes, greenbelt purposes. I think you were about to say that you were agreeing with the part two.
I was slightly different. Yeah, it's been assessed in part two of the Greenbelt review, and I don't disagree with. I think is it moderate, minor.
Yeah. So overall.
Well, I think the impact on openness is
we're on purposes now, Mr. Ford, sorry.
Purposes is minor.
Okay. Now, obviously, other potential, looking at the harm side of the equation, the council will be saying noise, and they'll be giving a weight to that, and they'll be saying parking issues, and they'll be giving a weight to that. Should those be given any weight in the balances on the harm side, so far as you're concerned? Noise and parking, are they harms that should be positively weighed?
Well,
that should be weighed in the
no, we
balance?
don't agree that there will be harm. My position is that there's a satisfactory noise environment, so therefore it's not harm. And similarly, I think the parking issue is a non-issue.
Okay, let's move on then to the benefit side of things, and this is basically very special circumstances as well. 68 houses, I think the council are saying substantial weight to that. What do you want to say about that in the context of housing supply?
I think if it was possible to add to it, I'd say very substantial.
And then 50% affordable housing, so that's 34 affordable
saying
homes.
Very substantial. I mean, I think some of the statistics I've put in evidence are they're utterly shocking, and I just don't know what this council's going to do, because it seems incapable of adopting a local plan. It's only had one in its lifetime. So yes, very substantial.
Okay, now the roads, the improvements to the managed trading estate roads that we've described earlier, what weight do you say those should be given in the balance?
I think the council have got this completely and utterly wrong. They just don't seem to appreciate the significance of what these improvements will achieve in relation to the strategy. So I say substantial.
Then there's the kind of regeneration process being kick-started by building these new units and the decanting and that cascade that we discussed. What weight should that be given?
Well, I think if we had absolute control over the whole estate, I'd say substantial. But in the absence of that, I think the elements we have got are really significant and should be weighted as such.
We've got the fact of the new employment space and the job creation that comes with that, which obviously it outlines, difficult to say with certainty, but the estimate is 50 jobs, and that hasn't been disputed, or at least so far as I'm aware it hasn't been. Ms Hutchinson didn't dispute it. So what weight do you want to give to those jobs and that floor space?
Well, I think bearing in mind that in Castle Point, I think 90% of the employment space is industrial, and that there has been no industrial development since the early 1990s. That's got to be significant.
There are then, in terms of other economic benefits, obviously construction, jobs, and contribution to the local economy from new residents and new employees. What weight will you give to those?
Well, again, just because there's been no advancement of the council's strategy in 30 years, it's got to be significant.
Biodiversity net gain, we'll look at it soon, but the 106 secures a 10% biodiversity net gain. How much weight should that be given?
I say moderate.
School drop-off and the pedestrian crossing, community benefits?
I think from a community point of view, these are huge, and I say that because of what the school said, and because of what local people said at the public meeting, and because of some of the consultation responses. You know, a net gain of 5 spaces where you can get out of your car safely has got to be, you know, really given some weight. And they're crying out, you know, this is the only school in the whole of the district that hasn't got a crossing point. And they're crying out for it. They really want it. I appreciate that's the community perspective. In planning terms, I weight it as moderate.
Okay, and then just to touch briefly on Heston Lodge, which I haven't really mentioned so far, but within the Section 106 agreement, there is provision made there for the transfer of a piece of land. So you'll see this in due course, the transfer of a piece of land, which the appellant says is part of their title and is being adversely possessed, and it's going to be transferred to them. Now the council is saying essentially that's not relevant at all. Private land matter shouldn't be given any weight. What do you want to say about it?
Like the last matter, how it matters to Heston Lodge is huge for them. It's part of the jigsaw. Glen, being Glen, takes a completely comprehensive approach, and we're trying to deal with all the issues that surround the site. In planning terms, I think it's of limited importance, but it has significances beyond that, which I think shouldn't be underestimated, and I think should at least give the point some benefit of the doubt.
So what weight would you give it then?
Limited.
All right. So I don't think we necessarily need to spell out what the balance overall is from the appellant's point of view. I want to just ask you one sort of final question, really, to finish off. You've talked about the jigsaw and assembling these pieces, and you know the kind of complex process that has been. Just sort of looking to the future. I mean, if this appeal isn't allowed now, this doesn't go ahead. This proposal doesn't go forwards. You know, what will the future look like for the Manor trading estate and for this piece of land?
Dire. I mean, it'll be business as usual, which is ongoing deterioration, ongoing degradation of the environment. The roads will go to the market. The Castle Point Borough Council doesn't want the roads. I don't think anybody in their right mind, unless they had a bigger picture idea, this was our bigger picture idea, would be interested in them at all. I hesitate to say this, but I kind of feel this. You know, if God gave the world an enema, he'd stick the tube in the Manor trading estate. You know, it's where all the waste is. It's where all the muck is. It's where people aren't bothered, and that's just going to get worse and worse. The local plan inspector, I think, has done the people of Castle Point a disservice by dismissing the qualitative improvements. I genuinely believe he got that wrong, and Glenn will just have to retire on the basis that he did his best. You know, it's been a whole generation, and people have got nowhere to live, and if they want to follow an industrial career, you know, they've got to go to Manor trading estate. I wouldn't want my children working there. It's shabby, and I think maintaining an attitude of lowest common denominator is seriously wrong with thinking. If anybody thinks that's the right way to do it. So the land assembly will just fall apart, and the cohesiveness and the sophistication won't be brought together again. It's the end.
Thank you, Mr. Ford. So I'm sorry that's taken longer than I perhaps thought it was going to, but
a bit.
There we go.
But there you go. Okay. Yeah, it's 10 to 12 now. so we got options. We could take a break, 15 minutes, and then start cross-examination. Your estimate was about 2 hours, so that would take us up to about 2 o'clock. Could break in the middle for lunch, or alternatively, we could stop now for a very early lunch, and then. So, do you have a view on that?
Perhaps, we start after a short break and then break for lunch at some point at a convenient moment.
Okay, all right. Yeah, okay, well, that seems to be the consensus. So we'll adjourn now for 10 minutes. Yeah, 10 minutes. Come back 12 o'clock.
So I think you might have to probably sit there, or I don't know where you'll go. Do you want anything
He's
brought to
okay
you?
at the moment because cross-examination.
True,
hasn't
yes,
started.
sorry, you're right. Well, okay, brilliant. We'll come and have a cup of coffee if you can manage one.
It's only when cross-examination. Right, it's 10 o'clock, so let's get underway. Before we do, though, can I just ask if there's any progress on the possibility of the council hosting a Teams meeting for the closing speeches?
Sorry, I'll just take quick instructions.
Yeah.
No, I've taken instructions. Yes, we can do it via Teams, and I'm told that Adam can use his if he's invited to the meeting, he can put that on the YouTube screening, so it can cover members of the public who want to view that as well.
Thank you. Yes, I needed to know before I adjourn this evening, because I need to adjourn to a specific time and place. So that's the reason why I asked. Okay, thank you for that. Good. In which case we can.
Presumably that link would be, because obviously there's a page on the council's website which has all the core documents on. So presumably the link for that meeting could also be put on, or is that not possible?
We'll sort that. We'll sort that out later this evening. I just wanted to know right now whether it's whether it was a goer at all. Sounds as though it is. We'll sort out the details later. Okay. So we'll resume. 3 minutes past 12 with cross-examination.
Thank you, sir. And Mr. Ford, can I start by asking you some questions on the framework, all right, national policy? And I know you'll know this, so if you want to go to the MPPF, do, but I'm going to quote from it, okay? On Greenbelt policy, we agree, don't we, that the appeal scheme is inappropriate development in the Greenbelt, paragraph 147.
Yes, that's right, yeah.
I'm grateful. And we can agree, can't we, that under paragraph 148 of the framework, substantial weight should be given to any harm to the Greenbelt.
Yes, that's correct.
In the planning balance, yeah?
That's correct, yes.
And we have here substantial weight substantial weight to the harm by reason of inappropriateness. Yeah,
that's correct. And any other harm.
Substantial weight goes to that. Yeah.
Yes.
And any other harm, we've got three elements now. Obviously, you have your case, council has their case, but we have aspects of openness. Yes, there's a debate about that.
I wasn't aware that was openness is part of the Greenbelt debate.
Yes, but you have in principle harm to the Greenbelt. All right. You can also have character and appearance harm to the Greenbelt, can't you?
Yeah, the visual aspect.
And you can have openness harm to the Greenbelt, can't you? Yes? So we have a debate about that.
Yes.
There's a debate about the noise environment and its acceptability and whether it can be suitably mitigated. Yeah?
Yes.
And there's a debate about adequacy of parking provision. Yes?
Yes, I agree.
And insofar as we have agreement, you can agree that the in principle harm carries substantial weight. Yeah?
Yes.
And in terms of openness, your position is, am I right, looking at visual and spatial aspects, that there's a moderate level of harm. Is that right?
Yes, that's correct.
What weight do you attach to that harm, please? It has to be substantial, doesn't it? Because it's any other harm under paragraph 148. Correct?
So would you ask me again, please?
So in terms of openness, you've given your evidence that there's a moderate level of harm. Yes?
Yes.
To openness in terms of visual and spatial. Yes?
Yeah, there's no buildings on the site and there will be buildings.
Correct.
So as a matter of fact, openness will be lost.
And we've just agreed that that's a separate element of harm, and applying paragraph 148, you attach substantial weight to it, don't you? As we've just agreed.
Can you just take me to my proof on that? See what I should mind.
Well, I'll show you where at paragraph 4.36. I mean, this is what you repeated in your evidence to the inspector. Page 17.
Oh, sorry. Too much paper. Here we go. Which paragraph, please?
4.36.
Okay.
taking all these long-studied characteristics together, the appeal proposal would amount to a moderate level of harm to openness of this particular greenbelt, yes?
Yes.
And I've taken that to as it says, that you accept there's a moderate level of harm to openness.
Yes.
What I'm saying to you is that is any other harm under paragraph 148 of the framework to which you attach substantial weight. Do you agree or not agree?
So yeah, so 148, I'm just thinking out loud, just making sure that I'm understanding your question and answering it accurately. So substantial weight is given to any harm to the greenbelt. So yes, there is moderate harm. So logically, 148 requires that is substantial weight. So yes, I agree.
I'm grateful. So what we can agree is, and the inspector will note, is that there is the in-principle harm to the greenbelt which carries substantial weight, and there is the harm to openness which you've agreed carries substantial weight. Yes?
Yes.
And then in terms of the noise environment and in terms of adequacy of parking provision, there's a difference between us on the facts, yes? So you don't assign anything to those, yes?
That's correct.
Now, in your planning balance section, because this is where this should, we should see this, that's section 12 of your proof. Is that right? Page 54.
Yes, planning balance and conclusions.
Yeah, that's where I should be looking, am I right? To understand, I suppose it's obvious, that this is how you draw the planning balance and you assign weight to the different aspects of harm and benefits, yes? Can you help me with where you acknowledge substantial weight to the greenbelt?
Well, it's not there, is it? That's why you're asking the question. I followed the same format as the Kennel Lane inspector in the way that I approached it, and if you look at the structure of that appeal decision, you'll find that my evidence follows that structure.
You are seeking to assist this inspector with a planning balance in a case which involves harm to the greenbelt, correct or not correct?
Yes, and I believe I covered that. I accept it doesn't say that in section 12, but I wasn't seeking to avoid saying it or to be misleading in any way.
And in order to undertake a proper planning balance, you have to acknowledge, or in lay terms, own up to the harm, don't you?
I believe I've done that.
And otherwise, you don't carry out a proper planning balance, do you?
I have conducted the proper planning balance. I'm aware of the factors.
Well, you don't seem to be in your proof, Mr. Ford, with respect, because nowhere in this section...
I've corrected it just now.
Nowhere in this section do you acknowledge that there is substantial weight to be attached to the in-principle harm to the greenbelt. We agree that, yes?
Yes.
And nowhere in this section do you appear to acknowledge the substantial weight that should be attached to the harm to openness that you've identified, correct?
That's correct, yes.
So there's two aspects of greenbelt harm where you've missed any reflection of the substantial weight that should attach to them, correct?
No, I've not missed it. I've just not
in your
expressed it
written
in
proof.
writing.
In your written proof.
Absolutely.
Yeah. And
that doesn't mean it's absent from my thinking.
It's implicit, is it?
Absolutely.
And in your evidence today, the inspector will have a note. I didn't hear you attach substantial weight to the in-principle greenbelt harm or what you referred to as a moderate level of harm. I didn't see you attach any weight to that either. Is that right or wrong?
That's correct.
Right. So in your written proof, the inspector can note you've missed those aspects. And in your oral evidence to this inquiry, in giving examination in chief, you've missed those aspects, yes?
No, in my oral evidence, I've said I attach substantial weight in accordance with the framework.
To me, when I've taken you to it.
Well, that's my oral evidence.
In examination in chief, taken through it by your own advocate, you have failed to reflect and acknowledge, or rather own up to, the substantial weight that you attach to those aspects of harm. Correct or incorrect?
I think that's semantics.
Am I right or wrong?
I've answered it several times.
All right. Paragraph 11 of the framework, insofar as, and as a matter of principle, Mr. Ford, insofar as any local planning authority cannot demonstrate a 5-year housing land supply the tilted balance applies, yes?
Not in this case, because of footnote 7, I believe.
Right, so let's take that in stages. Insofar as any local authority cannot demonstrate a 5-year supply, the tilted balance would ordinarily apply under paragraph 11D2, yes?
Yes, that's correct.
So you grant permission unless any adverse impacts would significantly and demonstrably outweigh the benefits, yes?
That's correct.
But we need to take account of, as you've just, I think, for the first time reflected, paragraph 11D1, correct? Whereby you would grant unless the application of policies that protect assets of particular importance provide a clear reason for refusal. Yes, that's what you've just referred to.
That's correct, yeah.
And that
It's
picks
correct.
up.
It's correctly expressed in Alison's Hutchinson's proof, and I agree with that.
And that picks up, doesn't it, footnote 7, which covers the Greenbelt as one of those assets of particular importance. Yes?
That's correct.
And in that sense, I'm right, aren't I? The lack of a 5-year supply doesn't automatically trump Greenbelt policy, because you get into a discussion about whether you can demonstrate very special circumstances, correct?
I agree.
And it's interesting to me, Mr. Ford, that you say Alison Hutchinson's proof sets it out properly. Does yours?
No, it's not. I made a mistake.
You made a mistake. Do you think it would have been helpful to have brought to the inspector's attention that mistake before I asked you about it in cross-examination?
I'm sorry, I've been working 60-hour weeks on this because of the shortened timetable. I apologise for not bringing it up. It was a point I was ready to concede upon reading Alison's evidence.
So your evidence is written wrongly on this point?
Yes, it was written. Yes.
So let's just take that in stages again. Section 12 of your proof is where we've got the planning balance. Yes?
Yes.
And there's no reference within that, is there, to footnote 7, or what we've just discussed, 11D1?
It's not there, I agree.
No. And in terms of what you do refer to, paragraph 12.1 on the top of page 54 refers to the tilted balance, doesn't it?
Yes.
So no reference to footnote 7, no reference to 11D1.
It's all part of the same point. They're not separate points.
And no reference to the fact that if you apply 11D1 and no VSCs are demonstrated, it disengages the tilted balance. That's the position, isn't it?
Yeah, absolutely. Yeah. I think we're in agreement.
Now, just to understand how that played out, you put that in your proof and you were working very hard. I can see that. You didn't take the opportunity to set it out in a rebuttal or a note to the inquiry? No?
Well, it's a very light point. I mean,
It's a very light point.
It is, because I've approached the determination via the very special circumstances, which is the right way to do it.
Not been covered in your examination in chief? Correct?
That's correct. None of this changes the substance of the case.
It changes the view we have of your evidence to this inquiry as an expert planning witness, Mr. Ford. Do you have any response to that?
I think it's cheap.
Okay, next, section 15 of the framework is about conserving and enhancing the natural environment. Yes?
Sorry, say that again, please.
Section 15, chapter 15, if you like, of the framework is about conserving and enhancing the natural environment. Is that right?
Yes.
Paragraph 174 says that planning policies and decisions should contribute and enhance to natural and local environment, yes, by a number of matters, yeah?
Yes.
And D includes providing net gains for biodiversity. Do you see that?
Well, it says minimising impacts and providing net gains for diversity.
Yes, I'm sorry, I read the bit that I'm going to, which is relevant. Do you see that?
I do.
Yeah, so planning decisions should contribute to and enhance the natural and local environment by providing, amongst other things, providing net gains for biodiversity, yes?
Yes.
So there's a national policy objective, isn't there, to enhance the natural environment by providing biodiversity net gain?
Well, there isn't a requirement yet. That date hasn't come in.
So listen to the question. We've just gone through paragraph 174 and looked at D, yes? And I'm reading to you what it says. Planning decisions should contribute to and enhance the natural and local environment by, yes, that's the first bit. And we go to D, providing net gains for biodiversity. Do you see that?
Yes.
Can we agree that national policy has an objective of enhancing natural environment by providing biodiversity net gain?
Yes.
Thank you. The point of it going onto a statutory footing, that's the Environment Act 2021, that's for later this year, it's not in force yet, correct? That's the legal position. Just on the question of cheap points, can we go to paragraph 11.48 of your proof, please? Page 52.
Yes.
So this is your section on biodiversity net gain, yes?
Yes.
Do we have reference to paragraph 174D in that section?
No.
And what you say in 11.48 is that the council, the planning authority, misdirect themselves on this point. And if we look what that point is, that's about biodiversity net gain, yes? And what you say is it wrongly suggests, paragraph 11.48, that biodiversity net gain is a necessary provision of the MPPF. Well, we've just seen it is a national objective within the MPPF under paragraph 174D, isn't it?
Well, just let me read what I did write before I answer that question, please. Yeah, so I think when you read it in the context of 180A, which was my reference,
Yeah.
I think it lowers that bar when it says planning permission should be refused if significant harm to biodiversity cannot be avoided.
I'm asking you about your comments about the LPA misdirecting themselves on this point, Mr. Ford. You've not made any reference to 174D, have you?
No, I haven't.
And we've agreed that provides a national policy objective to enhance the natural environment by providing biodiversity net gain, yes?
Yes.
So when the council says that biodiversity net gain is a necessary provision or part of or an objective in the framework, they haven't misdirected themselves, have they? By reference to because they're relying on 174D.
I don't believe there is a policy requirement to provide net gains for biodiversity.
Well, why have we just gone through that loop then, Mr.
Well, because
Ford?
you have to read the framework as a whole.
I've got a clear
and not just
note.
cherry pick half a sentence.
I've got a clear note that what you've agreed with me is that there's a national policy objective to enhance the natural environment by providing biodiversity net gain. And I think you said yes. Are you going back on that now?
Well, in the context of that half sentence, yes. But in the context
Yes.
of the whole framework, I don't think there is a requirement to provide biodiversity net gain. And if you don't, then planning permission should be refused.
Well, that's a separate question about the balance. I'm talking about
Well, I don't think it is.
174D, which,
I
if
think
I
it's
can
a
ask the
holistic
question,
point.
Mr. Ford, you have not reflected in your paragraph, have you? Or in this section on biodiversity net gain?
I've taken the point holistically and I've drawn a conclusion. I believe that the council has misdirected themselves. They've suggested that in the absence of biodiversity net gain, planning permission should be refused. And that's not right.
Can I just go with you then? If you're going to maintain that line, can we go to the officer report, core document A3?
Can I have the reference, please?
Yeah. I'm just going to check the inspectors with us.
A3, you said.
Core document A3 is the officer report.
I have it, and
Yes, and if we go to page 24, please, page 24.
the pages are not numbered, nor are the paragraphs, but so I assume it's page 24 out of 58 in the PDF.
I hope so, sir. The one I've got says no weight at the top.
At the top of the page, yes.
Grateful. Do you have that, Mr. Ford?
No weight, yes.
Yes. And if you go to the bottom of that page, can you see a heading, increased ecological value, the site?
Yes.
And just, I'm going to read the first few sentences there. The MPPF adopted local plan, a new local plan, all encourage, so the MPPF and others, all encourage and promote the achievement of biodiversity net gain. Do you see that?
Yes.
And that is consistent, isn't it, with paragraph 174D and the reference to the framework that we've gone to?
Yes.
The council has not misdirected itself by reference to that that part of the framework, has it?
Well, I'm going to have to read this whole section again rather than just take your word on that one sentence.
All right, well, before you do that, I'm going to take you to the second reference. Go to page 26, please. Page 26. And halfway down that page, Mr. Ford, do you see the heading provision of community infrastructure?
Yes.
Above that is the last paragraph of that section, all right, on increased ecological value.
Yes.
And it says it's considered that any proposal for the redevelopment of land, particularly within the Greenbelt, would be required to demonstrate the provision of measurable biodiversity net gain in accordance with the provisions of the framework. Do you see that?
Yeah, I don't agree with that.
Well, what I'm going to suggest to you is when you take those two references together, they properly reflect paragraph 174D of the framework, don't they?
No, at present, it's a no-harm approach.
No, that's a point about applying policy, Mr. Ford. What I'm telling you is the paragraph that you've not referenced in this section of your proof is the paragraph that the council officers were seeking to reflect in those references.
You can't refuse planning permission because there's no biodiversity net gain.
They haven't said that, have they? What they've done is can we agree this? They've properly reflected paragraph 174D in this part of the officer report.
No, it says it would be required to demonstrate measurable biodiversity net gain. Now, the implication of that is if there isn't demonstrable, measurable biodiversity net gain, then planning permission should be refused. And that's the wrong approach. And that's why I say they've misdirected themselves.
So the way in which you say they misdirect themselves is by an implication that you read into the officer report.
Yes.
Right. And what I'm going to say to you is when you look at those two references and look at the officer report as a whole, it is properly reflecting 174D of the framework, which has the objective that planning decisions should enhance the natural and local environment by providing net gains for biodiversity. As a reflection of policy, forget about how it's applied in the planning balance, how you say officers seem implicitly to have approached it. They have properly reflected policy, haven't they?
Your position is predicated on half a sentence in the MPPF. My position is predicated on the whole MPPF.
In circumstances where you've not referred to the relevant part of the framework, which is 174D. Have you?
I think my proof would have been about 5 volumes if I'd have made all those references at every point. The paperwork is, my thoughts and approach on the policy is absolutely correct. It is a no-harm approach, not a requirement for net gain. And on that basis, I believe the council has misdirected themselves. You're cutting sentences up and applying half a sentence to a point that's much more sophisticated than that.
Can you show me where the council has refused on biodiversity net gain?
Well, the implication of that sentence you've just read out to me is it is considered that any proposal for the redevelopment of land, particularly within the Greenbelt, would be required to demonstrate the provision of measurable biodiversity net gain.
Has the council,
in accordance with the provisions of the MPPF. I say that's wrong.
Mr. Ford?
Yeah,
yeah,
and that's the point that I made. And if you don't want to cross-examine me on the point that I made, then I can't agree with you.
It goes on to say, doesn't it, the satisfaction of policy requirement cannot be considered to represent a very special circumstance that would weigh in favour of the development of the site.
And that's the misdirection.
They haven't
Because
refused.
biodiversity net gain, yes, but that's because we've demonstrated biodiversity net gain. Had we not provided it, by virtue of this approach set out in that paragraph, they would have refused it. Because that's their position, as expressed in the report.
Is there any part of the decision notice that says there's no biodiversity net gain and therefore we refuse?
No, but that's because we've included it. If you take this paragraph at face value, had we not demonstrated biodiversity net gain, the council would have added another reason for refusal. But we did provide biodiversity net gain, which we say is a positive. In the absence of it, the council was saying it's a negative, and that's wrong, and that's the misdirection.
And what we can agree is that you are reading into the officer report what you think is implicit, but nowhere does the actual officer report refuse on that basis.
My logic is impeccable.
And nowhere do you refer to paragraph 174D in your written proof, or in fact in your oral evidence today. In examination in chief.
That's correct, but what I've said is I've taken the approach to biodiversity net gain holistically, and I've expressed that accurately and concisely. And I'm happy with that position.
Accurately and concisely.
The absence of half a sentence from the MPPF isn't fatal to my position.
When you're producing a planning proof for an inspector on which you're going to be examined, would it have been sensible to have referred to all relevant policies on biodiversity net gain in the framework, not just one of them?
Biodiversity net gain isn't in the reasons for refusal, so no.
Okay. All right, well, I think I've taken that as far as I can. Can I just stick, whilst we've got the officer report open, I just want to check something on the facts with you, if I can. Go back one page, on page 26, and if we go to page 25, please.
Sorry, it's in the officer report.
Still in the officer report, thank you. Page 25. Do you have that, Mr. Ford?
I do, yes.
Sir, do you have that? Yep. The top paragraph says the initially submitted preliminary ecological assessment was prepared in 2018 following a survey of the site. That report makes clear that at the time of the survey, the land had only recently been cleared. Indeed, removal of material was still ongoing, and that the ground was bare and recently tilled. Can I just check with you that those facts as stated are accurate, is that right?
Yes, I mean, there were 3 previous reports, but so there was a thorough understanding of the site, which led to the clearance of the scrub.
And the position as at today's date, I mean, we've got the restocking notice, all right? And there's not been a challenge, a judicial review of that notice, has there?
Yeah, I was the agent for the appeal, and I still haven't received notification from the Forestry Commission to date. Don't understand why. There is no present appeal.
Yeah, I'm grateful. I mean, I should be clear. There was an appeal against an original restocking notice. Yeah, there's not been a judicial review of the revised restocking notice.
That's correct.
And the finding of the commission into that appeal was that the site had been subject to felling of trees without there being a felling licence in place at the time. Yeah, that's why we've got a restocking notice. Yeah,
that was their finding. Yes.
And the results that results in a site of lowered ecological value, the felling of the trees and vegetation.
Well, if we're going to talk in these terms, I mean, I've got as much information. You know, there were reasons for why it was cleared in the manner that it was done. And really, I mean, I don't want to sound as if I accept the restocking notice, but there's a saying that a text without a context is a pretext. There was a whole series of studies and actions which led up to that, which are perfectly accountable in terms of the appellant's actions. And I think it's, I'm not sure where you're going with this, But
why don't we come back to my question? But if you want to finish, I'm not going to interrupt you.
the site is of lower ecological value now than it was
Thank you.
some time ago. Yes.
Thank you. Before the clearing of the trees, yeah?
Well,
it's of lowered ecological value
except
as
the
a result. Can I
but
just
the
ask the
scrub
question?
clearance-
Please, may I just ask the question, then of course you can answer. It's of lowered ecological value as a result of the clearing of the trees, isn't it?
Yes, but the advice was that. I mean, it's very. I don't really. I mean, I've got so much evidence on this. I don't want to waste inquiry time with it. But if you're implying that we acted in some way inappropriately, then I have to bring to the inquiry the absolute integrity with which we approached that that process, and that's why I'm kind of umming and erring a bit.
Yeah, Mr. Ford, just to be clear with you, I'm just trying to get some simple answers to some factual questions as we have the evidence before us, okay? And they're not complicated questions, and I'm grateful for you answering that as a result of the clearing of the trees, there's a lowered ecological value to the appeal site. So can I move on?
There is, but the advice was that the scrub was invasive, that it was affecting. I mean, I can read from the reports. It was felt that the excessive spread of scrub across the site was likely to be compromising the intrinsic interest of the grassland component of the site, which was the main reason for its designation.
And the net gain...
And there was a recommendation that the scrub be cleared. It is proposed that at a suitable time of the year, a large quantity of scrub is cut down. These areas then free from scrub will develop into grassland, which will increase the diversity of plant life on the site, and this in turn will encourage invertebrates. Now this goes back to the original studies about what the nature conservation interest of the site was. And so all the actions we performed were under the advice of two different ecologists, and which tied into its original site of interest for nature conservation. Now, we didn't cut down major oak trees. I can go through the statistics of exactly what we did, and it might be easy if I just read my conclusions to the Forestry Commission, because whilst they made a finding, it's rather odd that on an original restocking notice that required the planting of 2,000 trees, 2,000 trees, how can you get that so wrong? Down to 156. It's laughable. And in fact, it was laughable, but I can give you facts. It's not supposition. I can give you absolute scientific facts about what happened and the volumes and the content involved, and that it was done under specialist advice.
And what we know, okay, just to go back to what we have before us, Mr. Ford, what we know is that a restocking notice was issued by the Forestry Commission, and that was appealed, and you were the agent. You had a full opportunity to put forward all of your arguments. Yes?
Well, no, I didn't. No, I didn't.
And as a result of that, there was a revised restocking notice which has been issued and hasn't been judicially reviewed. Yes, those are the facts.
No,
yes?
no.
So can I just be clear then? The issue you take with that is whether you had an opportunity to put forward your case to the the committee. Is that the issue you take with that?
Yes,
Yes.
we had 7 days' notice, and we
Yeah.
were given a lever arch file full of information,
And that is an
most
issue.
of which was factually incorrect
Yeah.
and erroneous.
And that is an issue which you can take up through a judicial review as a matter of procedural irregularity if it has any arguable merits. Correct?
Yes, we weren't consulted on the areas
Yeah.
to which the planting could take place. I
That
think
too is a
probably
matter.
just to, because do you know what this is like? This is like the reference committee.
Yeah, I think I've had enough of that, because I'm not going to rerun the Forestry Commission's inquiry.
Okay.
What I understand is that yes, at the present time, the site has less ecological value than it once had, but I also understand it's the appellant's case that will regenerate of its own nature.
Okay.
So there isn't a reason for refusal on ecology. So I'm not really clear that you need to pursue it any more than that understanding that I've got.
I'm grateful,
If
sir.
you feel you do need to, then tell me,
Yeah.
and I'll hear you. But I think I've got enough.
I think I'm grateful, and I don't. I think the only further fact I just want to be clear about is part of that, in response to the inspector's question yesterday, part of that appeals process involved discussion of, am I right, the planning application that is currently before this inspector.
Well, we explained that the site was being promoted through the local plan and that we were cooperating with the council on that. We also explained that there was a current planning application.
Yeah.
The reference committee just said it's not within our remit.
Yeah, so the answer to my question is that the planning application was discussed as part, not the local plan, but the
No, it
planning
wasn't discussed. No, it wasn't discussed. I just said there's a planning application. The reference committee said that's not part of our remit. That was the discussion.
I see. And there's a meeting note, isn't it, which covers that? You've
Yes.
seen the meeting note. I'm grateful. All right. And I think I understand your position correctly. In evidence this morning, what you've said is that you would probably, rather than renegotiate with the Forestry Commission, you'd probably look to use your plan, which amends the areas to replant. Is that how you put it?
I like to solve problems and talk to people and see if we can narrow gaps. The Forestry Commission don't seem to work that way. The bottom line is we'll work with the adjusted areas.
Okay. Thank you. All right. So can I move next, please, to policy 2 of the Waste Local Plan? So that's in core document D2. I
Apologise. Every time, if there's a break, I have to put my password in again. Oh, and see, I'm getting it wrong now.
So core document.
Core document D2.
D2,
Core document
yes.
D2.
Got that?
And I'm sure you're well familiar with this. Obviously, matters of interpretation are ultimately, I think, a matter for the courts and it's objective. But I just want to get your take on this, Mr. Ford. Policy 2, page 44 of the document. So do you have that?
No, I think my D2. Oh, sorry. Yeah, I'm looking at the wrong place. My mistake. There it is.
Oh,
Page
44 is policy 1.
So I've got, 44 in the document.
Oh, so
not
yeah,
the PDF.
yeah, that's right. Yeah, 46 on the PDF.
I'm grateful. I think we're agreed, aren't we, that the first paragraph of this policy is about triggering consultation with the Waste Planning Authority,
That's correct. Yes.
and it's properly triggered here.
Yes.
Yeah. And then the second paragraph, proposals which are considered to have the potential to adversely impact on the operation of a safeguarded waste site or infrastructure, including the site allocations within this plan, are unlikely to be opposed where. And as regards those three limbs, A, B and C, I don't understand there's any dispute between us that A, I mean, this isn't a temporary permission which has expired or otherwise ceased. You're not arguing that applies, are you?
The waste management use, it depends because this position changed about 4 days before the inquiry.
Mm-hmm. But I just want a clear answer. Are you relying on A or not, Mr. Ford? Because I haven't seen that before.
Waste management has otherwise ceased and... No,
I'm grateful. And in terms of C, it's not a suitable replacement site or infrastructure has otherwise been identified and permitted.
Well, there's no proposal to remove the waste site.
No. And so, as I understood your proof, there was reference to, if I put it that way, B. Is that right? Are you relying on B or not?
Yes, yeah.
Yeah. So that says redevelopment of the waste site. Well, that's not what we've got here, is it?
No, but it's been put that if we proceed, there'll be severe pressure on the waste site to the extent that it might cease. So, but no, we're not actually on the waste site, but that pressure site, sounded fatal the way it was put. So I think it engages B, and I simply say to that, but this scheme has, I don't agree that it's fatal, incidentally, but in any case, our scheme has wider environmental, social and economic benefits that, well, it says outweigh the retention of the site. We're not trying to get rid of the site. The site will remain anyway. But there are, my simple point is there are wider benefits as listed in the second part of that.
So don't get me wrong, Mr. Ford. I can fully accept that your case to this inquiry is generally about wider environmental benefits. All right. What I'm trying to understand is the extent to which that properly comes within this limb of policy 2. All right. We're agreed. It's not redevelopment of the waste site, nor is it loss. Your scheme is not loss of the waste infrastructure, which would form part of a strategy or scheme. You don't control Benfleet scrap or any other safeguarded waste site.
No,
So if I
happy.
can just ask the question, your scheme does not involve, does it, loss of waste infrastructure?
No, not in any degree.
No. And so it doesn't meet that part of B, does it?
No.
I'm grateful. And so we don't get into the wider environmental, social or economic benefits. And just can I note this with you, in any event, even if you do get into that, do you see the last limb? And alternative provision is made for the displaced waste use. That doesn't apply here either, does it?
No.
So can we agree that you don't come within the wording of B of policy 2?
I agree.
I'm grateful. So that leaves us with the second paragraph, where there's a judgment to be made, isn't there?
Yes.
That if there's potential to adversely impact on the operation of a safeguarded waste site, there would be an objection, yes? And there'd be a conflict with policy.
Yes.
I'm grateful.
But the Waste Planning Authority didn't assess the noise report.
Yeah, and it's a judgment for them. Yes, I'm grateful. That's helpful on the interpretation of policy. And the waste disposal licence, I think you've covered this. I mean, there's no issue, is there, about the size of the site and the trigger for engaging this policy anymore? No. I'm grateful. All right. I'm going to move then to the operation of Benfleet scrap, and for this, I just want to check in your proof, please, which is section 7. Page 35.
Yeah.
This is the section on Benfleet scrap.
Yes.
And you say it's a known constraint to the appeal proposal.
Yes.
And you refer to the licences and the activities in breach of planning and licensing control. You refer to the unauthorised building. And as I understand it, I'm just trying to sort of get an overview of this. 7.44, what that amounts to is you refer to the framework and say you've got to assume that these other regulatory regimes operate effectively. 7.44.
Towards the end.
Yeah.
Yeah.
Page 41.
Yep.
Yeah. And that would, if they did, that would fairly relate to the ambience of the proposed development. And in 7.3, you talk about a lower working ambience if those were properly regulated effectively. Is that right?
Yeah, I think the noise baseline would be lower.
Yeah.
But they've never operated. I keep having to stress we don't have an axe to grind against Benfleet scrap. We just wish they'd behave.
Yeah. And so,
and if they kept their, we did a lot of noise measurements over a long period of time. If the scrap piles had been below 5 metres, and if they hadn't dropped scrap from heights that they were advised not to, from time to time, then the baseline would be lower.
So in terms of that aspect, it's the noise aspect that you're talking about with regards to that point. The context, I think we're agreed. You know, the MTE is an established industrial state since before 1949. Many of the units have been on the site since the 1950s and 60s.
Yes. When the Planning and Compensation Act came out in 1991, Benfleet scrap weren't there, but there was an old car breakers, and I did the original lawful development certificate for it so that they could get their licence.
Yeah, and many of the units are not subject to any planning conditions limiting hours of operation or excluding outside working or storage.
A Benfleet scrap?
No, Manor trading estate.
I haven't gone through it unit by unit. There are operational times on some of the planning permissions.
So if I say some of them don't have those limits, would you agree?
I don't know.
Okay, so that's in Mrs. Hutchinson's proof at 6.28. So I'm just trying to sort of see what you say about that.
Let's have a look then. Is that this one? Yeah.
Yeah.
6.28.
Page 33.
I think unless you've gone through it on it, I mean, a lot of the units have had planning applications from time to time.
Yeah.
And so, I mean, all you're really saying there is if there's something that's in its original state, it may not have planning conditions on it.
Yeah, so I'm just trying to see if we can get a degree of consensus, though, Mr. Ford. Okay, so you haven't looked at all of them, all right?
I've not looked at any of them.
But Mrs. Hutchinson says that some of them are not subject to planning conditions limiting hours of operation or excluding outside working or storage. Would you disagree with that, or you
I
just
don't know
say
what
you don't
Mrs.
know?
Hutchinson has looked at. I'm listening to her give evidence. I suggest she hasn't checked the planning history of the other units on the site, and it's an assumption.
So I'm just asking you, as someone, you say you've been a number of times to the Manor Trading Estate, is that a fair summary or not, or do you just want to say you don't know?
I don't know.
I'm grateful. And most of the safeguarded sites are reliant on external working and storage. Agree or disagree?
Yes, I mean, yeah, a bit of both really. Yeah.
Grateful. And we have B2, predominantly B2, but also Class E, B8, and the sui generis uses, which are the safeguarded waste sites, as a mix.
Across the whole estate?
Yeah.
Yes, I mean, the prevailing character is industrial uses. You've got some of the sort of, if you like, the supportive things like the cafe and the gym. And then obviously there's the waste sites as identified in the plan.
Yeah. I'm grateful. So, and then moving to Benfleet scrap, it's a long established scrapyard.
Yes, from I think it was 2002, 16/02 was the original permission.
And it's an open site in terms of its metal crushing.
Yes, I only know what I've seen from outside the site and from aerials. They do have buildings. I don't know what takes place in the buildings. And
it dismantles cars and recycles various metals.
No, it doesn't dismantle cars. No, they're done on another site. They sometimes bring, if you like, the carcass of the car and crushed out, but they've stopped doing end-of-life vehicles.
So sometimes have carcasses of cars, but they recycle various metals.
Yeah.
I'm grateful. And it just against that background, I just want to explore with you, this is on all on the operation of Benfleet scrap. Firstly, when considering whether something's a nuisance, it would be right to take account of the environment and character of the area and the uses of that area, wouldn't it?
Yes.
And with regards to enforcement, it's a well-recognised principle of enforcing authorities, isn't it, that you take a proportionate approach to enforcement, yeah?
Yes.
And that's whether it's in planning or in lots of regulatory areas, yeah? And that involves, doesn't it, a staged approach to enforcement.
Sorry, what do you mean?
A proportionate approach often involves a staged approach. You don't just go immediately for, say, prosecution. You need
to understand what you're dealing with.
Yeah, and you often go through a process of informal contact, formalising contact, discussion. That's the sort of process of enforcing, isn't it?
Yes, and I sought to engage the council on that.
Yeah. And
that process didn't start. So I formed the view that they weren't concerned by it.
Yeah, and what that means is, isn't it, that often, I'm saying as a matter of principle, okay, a technical breach of, for example, a condition does not automatically lead to formal enforcement action, does it?
No, I mean, formal enforcement action is, sort of after you've done 98% other, it's the last resort.
Yeah, I'm grateful. And with regards to noise, you haven't asserted, I haven't seen anywhere that you're saying that Benfleet scrap have been operating beyond their hours restrictions.
No. We've got the monitoring. We know exactly when they've been operating.
Yeah.
We've got CCTV on the site, so we know exactly what's happening.
And what you do refer to is you link the height of the scrap metal piles to noise. That's the point you take in your proof, isn't it?
Yeah, it has a visual impact, but I've not. It's a secondary point that I'm not making.
No,
yes, I do relate it to noise. Yes, because
I'm grateful.
Because they've got a 5 metre eastern boundary.
Yeah.
You know, if they were no higher than 5 metres, then any noise that was created behind that wall would be baffled to some extent by the scrap pile and the wall. That's not happening.
Yeah. And so I just want to take you to this part of your proof, please. If you look at page 41 of your proof, page 41.
Yes.
I'm grateful. And the top paragraph there, so sorry, we better take it from the page before, bottom of page 40. Metal piles created higher than the 5 metre boundary require the material to be lifted higher than otherwise necessary and dropped from and to a more exposed position. And then you talk about a friction sound of metal on metal falling down the slope of the scrap pile from an elevated position greater than 5 metres and then over the north wall would create an extreme noise impulse, yes?
Yeah, the north wall is actually 2.75 metres.
Yeah.
And they have been advised not to put anything above the height of that wall next to it.
I just want to understand that, Mr. Ford. You're not a qualified acoustician, are you?
No, I'm not. No,
and you put that forward from in that sense, a lay, a planner's perspective, but a lay perspective. It's not an expert view on the noise that would arise from the friction sound.
I'm a trained scientist in physics.
Yes, but you're not a qualified acoustician, are you?
I'm not, but I'm trained. All right. I'm trained in physics to a degree level.
Yeah, and have we got any technical assessment of drop heights and the difference that would make to certain operations in terms of noise before this inquiry?
It's just a factual observation.
I'm grateful. It's a factual observation, and
I've watched them do it.
Yeah,
and the way we've seen cars fall over the northern wall.
Yeah, and the way that works in terms of the licenses, as I understand it, is that's if you look at your proof, 7.39 is where we are. As I understand it, that goes to the 5 metre point. Is that right?
Well, and the 2.75 metre.
Yeah.
In the licence, in the annex of the licence, it says don't stack over 5 metres.
Yeah.
But a bit in other places, and I don't know if it comes out of the visits and the recommendations, but they're not to stack above the height of the 2.75 metre wall in proximity to it.
But I'm just trying to understand where the point goes. If you go to page 36 of your proof, page 36. What you refer to, because you've given us, helpfully, you've given us some references to the licenses. Do you see in the centre of that page, you refer to condition 6.9?
Yes.
And that's where you get the reference to the 5 metres, yes? I'm grateful. So when you're talking about that point, which you've fairly accepted with me as a factual point, all right?
Yes.
And the stacking over 5 metres, it's directed at a concern about whether there's compliance with condition 6.9. Is that fair?
All I'm saying is that they operate outside that on a fairly routine basis.
Yeah. So let's just understand that from the licence, please. Can we go to core document I2?
Ooh.
And you've just...
Control of Pollution Act 1974.
Yeah, this is the waste disposal licence, isn't it?
I'm sorry, I missed the reference.
Sorry, it's core document I2.
Oh yeah, 39898.
Do you have that, sir?
Yep.
I'm grateful. And if we go through, we can see the licence, and there's a number of schedules, and the conditions relating to this licence are from PDF page 3. Do you have that, Mr. Ford?
Sorry, I dropped down to 6.9. I'll go back
Okay,
up.
so I'm just taking it in stages. Schedule 3 on page 3 is the conditions relating to the licence.
Yes, that's right.
I'm grateful. And then we go down types of quantities of waste, site infrastructure, plant and equipment, number 5, and then site operations. Yes?
Yes.
And that's site operations is on page 5. So are you with me on that?
No.
I'm grateful.
Yep.
And just looking through those conditions under site operations, all right, so this is to do with, as you might imagine, deposits and waste on the site, isn't it? Batteries and where they're stored.
That's right, yeah.
So I'm on page 5, all right, and looking down that list of conditions, all right, because it's headed site operations, and it's about just that, isn't it? Operations on the site.
Yes.
Yeah, and and safety matters on site. Yeah, that's what they're broadly what it's covering.
I guess there are safety implications for all of these.
Yeah, I'm grateful. And then if we just drop down just to get the context, the next section, section 7, is on environmental controls, isn't it?
It is, yeah.
Yeah. And then after section 7, we've got, for example, the working hours, section 8, and
Yes.
we've agreed the position on that. I'm grateful. So in that context, site operations about waste on site and safety on site, and environmental controls being the next section. Can we just look at 6.9, please?
Yes.
So this is in the section, isn't it, on site operations, which we've agreed is about safety on site. And what it says is, all controlled waste shall be stored in a safe manner. So as we can see, that's the theme, it's about safety. In order to ensure public safety, no waste material should be stored or stacked to a height greater than 5 metres. Yes?
Correct, yeah.
So it's in the context of storing waste in a safe manner in a section on safety of site operations on site that we get the limit of 5 metres for stacking that material. Correct?
Yes, and in the reference to the 2.75 metre wall, it also explains that that's for safety purposes as well, so that material doesn't overtop the wall and fall onto the appeal site.
Yeah. So that condition we can agree is about safety, not about noise, isn't it?
No, I don't agree with them on that. Because if they exceed it, there's a noise consequence. That's all I'm saying.
Yes, but we've agreed, as you've just gone through with me, Mr. Ford, this section 6, is about site operations. You've agreed that. You've agreed it's about safety of operations on site. You've agreed with me that the next section is about environmental controls, and the one after that is about working hours. And you've agreed that the wording of the condition itself is about storing material in a safe manner on site for public safety purposes. It doesn't say anything about noise, does it?
No,
and
it
that's
doesn't.
not how you read it.
But the consequence of not satisfying 6.9 is that you get an increased noise environment as night follows day.
And looking at the context we've just discussed, all right, we've agreed that a technical breach of a condition does not automatically lead to formal enforcement action. We've agreed that. And looking at the context in which this condition arises, which is under the heading of safety of operations on site, not noise, it's a judgment for officers, isn't it? Regulatory officers, in this case the Environment Agency, as to what they would do if the height of the materials is stored above 5 metres, because it's in a section of the waste disposal licence which deals with safety, not noise.
And what they do is they say to Benfleet Scrap, you need to reduce your scrap piles.
So
They do that on their inspections.
Yeah, let's just see how that plays out. And sir, I'm aware it's 1 o'clock. but just to finish this section,
Yes.
I've got about another 10, 15 minutes, if that's all right.
Yeah, go on.
So let's look at the enforcing authority, the Environment Agency's approach to that, and how they look to enforce that. There's compliance inspection reports in core document I.
Yeah, there's been one missed off.
Yeah, we'll come to that.
think
Can
it
I
was the
take
one-
you to
I think it was the
I9,
one we
please?
provided.
Can I take you to I9? And that is a compliance inspection report. So I'm going to try and take these in chronological order, okay? I believe there's 4, and you've mentioned one that I think we need to mention. But this one is 12th of June 2018, yeah? Page 1.
Oh, sorry, I've dropped down again.
Sorry, I think I've got the wrong one.
So I am on core
12th of
document
June
I,
2018.
yeah, core document I9.
29th of May 2018 is what I've got.
No, that's the date of the inspection.
Ah,
There's another date for the date that the report was issued, which is to the right and down from that.
oh
Yeah,
yeah.
I'm so
12th of
sorry. Yeah,
June,
I'm looking at the date issued. Quite right.
Yeah.
But it's so May 2018. Yeah, for the date of the assessment. Yeah, is that right? Yeah, I'm grateful. And if we go down that one, please, to the 3rd page. Yeah, can you see on page 3, C4, category 3 breach?
Yes.
Yeah. So are you with me in the middle of that page?
I am,
Page
yeah.
3.
Yeah.
No, sorry, I'm talking to the inspector.
Oh,
on that one,
sorry.
Sorry.
I can't. If I'm looking here and then I look up, I can't see which
I
way
know.
you're looking.
I know. And it refers to this a swath bay. The new concrete bays are 5 metres tall, and this makes it easy for everyone to determine waste pile heights. The steel swath was clearly stored to a height in excess of 5 metres. Yeah.
Yes.
Although you had been let down by hauliers who were due to remove some of your waste and therefore reduce the pile size, you must actively manage the issue to resolve the problem as soon as you notice it. Yeah.
Yes.
So there's an acknowledgement there that as to why that's happened, and advice is given as to what the action needs to be. Yeah.
Yes.
And from there, so we can see that's an issue about pile heights and what is said about it. If we just go on, please, to page 5.
There's also the root cause recommendation which follows that, isn't there?
Yeah. Management
Yeah.
systems.
Management systems, thank you. And if we go on, please, to amenity, which is page 5, can you see it says no issues were identified in relation to noise, odour, dust or vermin?
Where are you on the page?
So page 5 has a box.
Oh, so
and in
just the
middle
very
of
last box.
Yeah.
Yeah, I see that.
Yeah. And what I'm going to suggest to you is that is entirely consistent with a proper reading of the waste disposal licence. Where there's an issue with increases above 5 metres, that is not read or interpreted as a noise issue. What it's interpreted as is an issue for the 6.9 condition and safety on site. All right, and that's why the mere fact of being above the 5 metres is not referenced as a noise issue. In fact, there were no noise amenity issues on that day.
Well, that was in the context of a site visit that lasted for 1 hour and 45 minutes, and in which the inspector didn't go to. We don't know what he did.
Yeah,
It doesn't mean there weren't any noise consequences. It means that the Environment Agency got the piles reduced slightly. But the instances of noise arise from the excessive piles. It makes it slightly high, and that's the point. That's the only point.
I see that's what you say, all right, and I'm just trying to look at how that comes
But it's
out
scientifically
in a
true.
regulatory regime which is enforced by the Environment Agency. So that's 2018. All right. Now, I believe there's a compliance inspection report from 2019 which you submitted. Is that right?
We put one in, yeah.
Yeah, and I have to say I'm not sure. I haven't seen it in this core document list.
No, all our core documents didn't make it.
It was on the list that was.
Sorry.
Anyway, it was on the list that was hard copy on day one, but I don't think it ever made it onto. Or at least when I checked, that was one that had been missed off the website.
Okay. Well, that's a document that I think you submitted. Is that right, Mr. Ford?
Yes.
Yeah. And the way I'm going to try and deal with it, so we can deal with it before lunch, and we can get it and it's available. All right. Is that one was talking about, and that was the September 2019. Does that ring a bell?
Without having it in front of me, I can't recall
Okay.
that at all.
Right,
I need to see the document.
All right.
But I mean, I'll take it from you.
Yes. Why don't we do it this
But
way?
if you're asking me, is that right? I don't know without.
All right. If I say to you,
physically
it's
looking
talking
at
about a grab crane putting material into an upturned shipping container, and advice was given that the drop height be reduced. Yeah,
That's
does that ring a
correct,
bell? And the dragging of waste metal was raised as an issue.
Yes.
And it was asked, please consider it in using a wire system to do that. Yes.
Yes.
And that one too was advice given. Yeah, that was
Yes.
the level of enforcement that was taken. Yeah.
Yes.
And that was, I believe, September 2019. But obviously, check the date, and if I'm wrong, come back.
No, I don't. I'm not.
I'm grateful. All right. So that one we've covered. If we then go to just to complete the sequence, all right. The next one is I-10. I-10.
Yep.
And this one. So do you have that? And this one is June 2021. Yeah, so we've looked at 2018, 2019, now June 2021.
Yeah. Date of inspection 14th of June.
Yeah.
He's on site for an hour and 15. He
Yeah.
issued his report on the 28th of June.
Yeah. And we can see on this one, no breaches recorded, page 1 of 6.
Where are you, please?
Page 1 of 6.
Although I've read these reports, I'm not familiar with their
Sure.
format.
Bottom of page 1.
1 of 6. Number of breaches recorded 0.
Yeah.
Yippee.
And in terms of page 3, and in terms of what it says about noise.
Yeah, at the bottom of page 2 of 6,
Yeah.
it records swarf falling over the back wall into the channel, which is beside the appeal site. Completely unacceptable.
And just going through to page 3 then, can you go to page 3 for me?
Yeah.
Can we see the summary box, the penultimate one?
Yes.
Overall, the site was compliant at the time of the inspection. There were no issues with odour, vermin, dust or noise detected on the site or its surroundings during the inspection.
I'd like
Can I just check, sir, do you have that first? I'm grateful.
Can I just go back to the one before, because you read it out but didn't ask me a question.
Yeah.
If you drag metal along the ground, I mean, you know that if you run your fingers on a blackboard, the noise that it makes. If you drag metal along the ground, there's a coefficient of friction there which generates heat in the metal and a noise impulse. And that is a consequence of that action. So whilst it's not covered in the report, there is a scientific consequence of that action. And so whilst the Environment Agency remedy is to stop dragging metal, stop dropping metal, in a safety context, the consequence is outside the safety consequence in terms of the generation of noise. And that's all I'm saying in my evidence.
Yeah. Is there anything in the subsequent report from the Environment Agency, and that's the one we're looking at now, 2021, to indicate that that remained an issue at that time?
Which one?
The dragging of metal that you've just taken us through?
Not in that report, no.
No. And can we then just complete the sequence? If we look at I11.
Oh, sorry. Yep.
And this one is April 2022.
Yep.
And again, if we just go down to the bottom of page 1, no breaches recorded.
Correct.
And if we go to the bottom, page 2, in the box, the summary, overall the site was tidy and there were no issues noticed with regards to noise.
Sorry, where were you? Oh, summary, yeah.
Summary, overall the site was tidy and there were no issues noticed with regard to noise, pests or dust during the inspection. Do you see that?
Yes.
Yeah. So
there's a reference in the box below, which I'm trying to work out. It says, other than the provision of advice and guidance, at present we do not intend to take further enforcement action in respect of the non-compliance identified above. This does not preclude us from taking enforcement action if further relevant information comes to light or advice isn't followed.
Yeah, so if I just ask you about that then. Section 3 is a tick box section, isn't it? Which allows the officers to gauge at what level they're thinking about enforcement action. Yeah. And in all of the reports, actually nothing's ticked in this one, presumably given the comments. But in the previous ones, it only ever gets to advice and guidance the first. Is that fair?
Yeah, fair.
Yeah.
I mean,
so what we can...
if they keep their heights to 5 metres
Yeah.
and stop dropping and dragging metal,
Yeah.
then we'll get a baseline that is fair.
Yeah. And what we can see from that, isn't it, is that apart from in 2019, when advice and guidance was given, all right, as to drop heights, there's no current, is there? There's no current reference to there being any exceedance or non-compliance or any issue to do with noise with regards to the waste disposal licence.
Well, there's never any reference to noise because, as you said, it's a safety point.
Right.
But every day, the scrap pile is higher than 5, which is most days, then there is more noise than there should be.
Yeah, and we don't have any technical acoustic evidence to support that point, do we?
Well, it's my evidence of this inquiry. We heard about the Elsenham case where there was an elevated motorway, which was a problem with noise which couldn't be mitigated. What we've got here is an elevated scrap pile. Yeah. It's the same principle.
And
the noise comes from the point that the dropped metal hits the top of the pile. That's higher than it would be, and its propagation across the site, it's a pressure wave, would be greater than if that pile was at the lower level. If it was at the lower level, you'd get the buffering of the scrap pile below 5 metres, and you get the buffering of the 5 metre boundary wall. It's just trite science.
To be fair, to witness, it's even at the level of noise training that I get as an inspector, it's understood that direct line of sight is what propagates the noise, and a physical barrier, help of any kind. And the mass of the physical barrier then influences its effectiveness. But the point about the direct line of sight is well understood, even at the level of acoustic noise that
I don't take a direct line of sight.
And I think that's the point that he's making, that as soon as you get over the 5 metres, you've got a direct line of sight onto the.
Oh, I see. Okay, well, I'll make submissions on that based on the inspection reports, but yeah. I see the point that's being said. Can I just move that forward then? In terms of the licences, so permission and the licences, we've got a permission from 2002, waste disposal licence, waste management licence and scrap metal licence. There's nothing in any of those permissions or licences which limit the number of items of plant or machinery on Benfleet scrap.
No, I think the limit in intensity of use comes from the 5 metre restriction, the actual amount of land they've got available to manoeuvre. They have to bring in lorries through the access road. They have to offload it somewhere. They then have to move it and process it and then put it somewhere else, maybe cut. And they've got a finite amount of space to do that.
Yeah.
And we know from that management report that they have to manage their inputs and their outputs very carefully, and the Environment Agency encourages them to do that so that they don't get an overburden on site, that they can move out the processed metal before the next load comes in. So there is a natural limit due to the finite amount of ground available.
So natural limits, but in terms of the licences and conditions, we can agree the point. There's no nothing limiting the number of items of plant or machinery on Benfleet scrap.
No, but there needs to be a process which works its way through the yard.
Yeah. And you heard Mrs. Hutchinson's evidence, and I think you would have seen it in writing. You know, the throughput per annum on the waste disposal licences, I think 75,000 tonnes per year.
Yes, that's what the licence says, yeah.
And do you accept Mrs. Hutchinson's evidence that looking at the most recent data, she cites, I think, 27,000 tonnes in 2017-18 on an annual monitoring report. But she did say that fluctuated, I think, up to about 50. Can we agree? Do you dispute those figures?
No, I agree. I mean, it's inevitable there'll be fluctuation. I deal with waste site at Pitsea Flyover, and this economy of space, moving materials, the next destination letting you down. It's part of the day-to-day management of a scrap site.
Yeah. It's not operating. So the highest figure that Mrs. Hutchinson referred to is, I think, up to 50,000 tonnes for an individual year. It's not operating at capacity as in terms of its throughput, is it?
No, and I don't know whether it could ever operate at capacity. There needs to be some kind of workflow understanding to test that out.
And then in terms of the certificate, so the clopid that was granted, I hope we're clear on this and don't need to go to it. We can agree it was an installation of replacement plant for an aluminium recycling machine.
Yes.
And it included, I think, a super chopper and a multi-purpose rasper.
Yes.
Located at the southwest corner of the site, according to the plans on the certificate.
I think it was just south, wasn't it? It was at the south end.
South or southwest, fine. And it was granted because of permitted development rights.
Yes.
And as a certificate, there's no conditions on that, obviously.
No, you revert to the licence conditions.
Yeah. And that was an open operation as set out on those plans.
Yes, it's in the yard.
And so where we get to is, in your proof you say there were legitimate concerns. That's the way you've put it. There were legitimate concerns with the operation of Benfleet scrap.
Yes.
And I think I'm right. You know, you've helpfully said it today. From time to time is how you put it. From time to time, there's an issue with drop heights.
Yeah, I think that's fair for the drop heights. I think the waste pile is too high most of the time.
Yeah, but the drop heights is the point that goes to noise. Is that fair? That's what you're saying.
Well, if you've got an over high scrap pile and you're working that pile, then even if you are placing, bearing in mind the scrap can slide down the pile and there's a coefficient of friction and it'll generate noise, it's still a problem. Dropping just makes it worse.
I see. So it's the pile height and the dropping, yes? There's no evidence, is there, that Benfleet scrap is currently operating outside of its licensing regime or planning permission? We don't have that before us. What we've looked at is the EA reports and everything else.
Just every day that I visited it. That is my evidence.
And it's a very significant constraint on residential development, isn't it, of your site?
It's a constraint, but as I go back to 2018, when I raised it with the council, they weren't concerned. When I raised it with the council's environmental health officer, they weren't concerned. They were so unconcerned. I don't know what happened. But that passivity on the noise issues is an indication of contentment.
Thank you, sir. That's an appropriate moment.
You have more to continue with?
I do, yes.
Yeah, okay. Right. Just make a note of that previous response. So it's now 1:20. So the suggestion is we adjourn. Do you want a full hour, or should we come back at 2 o'clock?
2 o'clock's fine.
2 o'clock's fine? Okay. So we'll adjourn now until 2 o'clock. Mr. Ford, you're probably well familiar with the conventions that you'll have to be in isolation, I'm afraid.
Peace and quiet.
Yeah. Okay, see you back at 2 o'clock.